All right, the record should reflect now that the defendant is present with counsel. You may be seated if you wish. And would counsel state their appearances for the record?
Good morning. Robert L. Shapiro and Sarah Bowman for Mr. Simpson.
And good morning, Your Honor. William Hodgman for the people.
Marcia Clark for the people. Good morning, Your Honor.
Good morning. All right, there are a number of matters on calendar today. I think one matter that can be resolved in fairly short order, and that relates to the hair sample, that the court did grant an order for a hair sample. The defense submitted an order to the court requesting to limit that hair sample to one hair. I did have my clerk contact the district attorney's office to determine whether they were in agreement with that order, and the indication was that they were not, and therefore I've done nothing with regard to that order to this point. Ms. Clark, how much hair do the people need?
Well, Your Honor, hair samples, as I'm sure the defense must be aware, in order to be effectively compared with an evidence sample recovered from a crime scene, has to be taken from each area of the suspect's head. And that means that a minimum of 5 to 10 hairs from each area, which usually amounts to about 100 hairs. Any scientist, no matter how inexperienced, is aware of that fact. You cannot do an effective comparison between a known standard and an evidence standard without that size of sample.
So you're asking for 100 hairs?
We're asking for as many hairs as the criminalist or expert determines is necessary to effectively compare the standard hairs from the head of the defendant with the hairs found at the crime scene. And I've never seen a court attempt to restrict that, because that is obviously the matter that a criminalist would have to determine based on what he can recover.
Mr. Shapiro?
Your Honor, according to Dr. Henry Lee, our chief criminalist, who is the head of the Department of Criminology in Connecticut, he tells us 1 to 3 hairs are sufficient. I think perhaps this may be an appropriate matter for the court to have a hearing on. I think 100 hairs is unduly invasive. Makes the inventorying of the hairs a very, very difficult task, and certainly allows for the possibility of the commingling of samples, which could contaminate any test. So we would ask for a hearing on this. I've been practicing for a long time. I've never, ever heard of such a request.
Right. This is what I'm prepared to do at this point in time, and that is to order no more than 10 hairs at this point. If the prosecution at some point feels that they are in need of more hairs than the 10 that I'm going to allow at this point, then we will have that hearing with experts if necessary. This is not a matter that the court has independent expert knowledge concerning. So that's going to be the order at this point in time, subject to a further hearing with evidence, if necessary, from both sides for anything beyond 10 hairs.
Your Honor, I don't think that counsel has conferred with Mr. Lee concerning the nature of the test involved. If Mr. Lee if Mr. Lee has informed counsel that only 1 to 3 hairs are needed for microscopic comparison, then he has misinformed counsel, and I can state that categorically. I'm very surprised to hear Mr. Shapiro has never heard of the number of hairs I have just indicated to the court being required before, because that is a standard thing. When a microscopic analysis is endeavored, it is required that you have standards from every area of the head, 10 hairs per area. That's a standard. I'm not talking about anything unusual here. Right, and what Mr. Lee is talking about, Your Honor, is PCR work. That's a whole different thing. We're not talking about comparison only for PCR. We're talking about comparison for microscopic as well.
All right. This is what I indicated I was willing to do at this point. You're of the opinion, and it may indeed be the correct conclusion, that you're going to need more than that. And the bottom line is that if, in fact, you do need more than that, you are going to have to produce an expert to justify that to the court. And if indeed that justification is made, I will sign an appropriate order.
Thank you, Your Honor. We will present that testimony today.
Today?
Yes.
Very well.
Thank you very much.
Okay. Now, yes.
On the matter before we do that issue, we do not have an indication as to how many follicles or shafts were found that the people are going to use for a point of comparison. And we asked the court to consider it for you so we would have knowledge of that now.
Yes. Ms. Clark, do you know the answer to that question at this point?
I I was told just this morning, and I have not recalled, I'm not going to make a representation. We have an expert here who can tell the court precisely how many follicles and how many shafts there are.
All right.
I'd rather let them say.
Now, you indicate you do have an expert here. Do you want to proceed on this issue of the number of hairs right now, or would you prefer to do that sometime later? What is your preference?
Well, Your Honor, as I understand it, the court had required us to proceed this morning on the issue of the blood split that was requested. So the expert who is going to testify to that matter can also address the matter of the hairs, because she's the director of the crime lab for the Los Angeles Police Department. So we can do it all at once.
All right, that would be fine. Mr. Shapiro, I assume that you're prepared on the hair issue?
Yes, I am.
All right. Then let's then in conjunction with the determination of the number of hairs, there remains the determination of the sufficiency of certain blood samples for defense splits. Now, I also should mention that the court is in receipt of the defense motion that was filed to quash and traverse and to suppress certain evidence, and attached as an exhibit to the defense motion was a property report listing certain items of evidence, I think 1 through 34 are denoted there. Is it correct that all of the scientific evidence about which that we're speaking about splitting is included in those items 1 through 34?
I don't believe so, Your Honor. I believe there is scientific evidence related to items recovered at the scene of the homicide, 875 Indy. The motion only goes to the evidence that was obtained at the home of Mr. Simpson.
All right. Does anyone have something to provide to the court with a listing of what specific items we're dealing with if there's going to be different testimony concerning a particular item that was received in evidence, and the court would ultimately be making orders perhaps differing or designating certain samples that would be split and certain samples that would not be split? It would certainly be helpful to the court to have some sort of a number, and the way it's denoted in the property report would make sense, since that's the way all of you will be dealing with the evidence and the criminalists as well. Is there a copy of a property report that could be made available just for the court's use in keeping track of the items of evidence, scientific evidence that we're dealing with, that either of you might have?
And I do that.
Okay. If somebody could hand that to my clerk, it would greatly assist me during this motion. All right, then I guess then we'll just commence with the testimony with regard to the splitting of the evidence at this point in time. Ms. Clark.
Thank you, Your Honor. People will call Michelle Kessler.
Please face the clerk and raise your right hand. I do.
Michelle Kessler, M-I-C-H-E-L-E, K-E-S-T-L-E-R.
Thank you very much. You may inquire.
Good morning, Ms. Kessler.
Morning.
Please tell us what you do for a living.
I'm employed by the City of Los Angeles Police Department, and I am the Assistant Laboratory Director for the Criminalistics Laboratory.
Tell us what that means. What are your duties?
My duties include the managing and overseeing of several areas there, including the serology DNA lab, the trace unit, and many of the other units there.
And what does that mean? What exactly do you mean by that?
Well, in managing, it also means evaluating and implementing programs such as serology and DNA, and including evaluating crime scenes and managing task forces or large cases and the employees that are doing the work.
So you direct the criminalists in what to do, basically.
That's correct.
Were you once a criminalist yourself?
Yes, I was.
Tell us what a criminalist is.
A criminalist is one who collects, preserves, and analyzes all types of physical evidence and testifies in court.
Now, does that mean it's somebody that goes out to a crime scene to collect evidence from the scene
Yes,
of a scientific or evidentiary nature?
that's correct.
Have you also performed trace evidence analysis or blood analysis?
Blood years ago and trace years ago also, yes.
What kind of training did you receive in order to get the current position?
The training in the current position is basically a management position, so I have taken several management classes, but the criminalist position, my training and background includes a master's degree in criminalistics from Cal State University, and then on-the-job training, including courses at the FBI laboratory and California Criminalistics Institute and various other private classes.
And how many years of training is that?
Overall,
Overall.
Master's degree is 2 years beyond your bachelor's. I have probably about a total of 4 years, 6 years invested there, and training in specialty classes probably about another 2 years full-time training if you were to separate it out compared to on-the-job work.
Now, you have your master's in what?
Criminalistics.
And criminalistics, the subject is defined as?
Again, criminalistics is forensic science or all areas of evaluating forensic evidence.
Now, when you say evaluating forensic evidence, Ms. Kessler, what does that mean in terms of your knowledgeability about which tests are available and appropriate to be performed on various types of evidence?
One of the things that a forensic expert must look at in any type of physical evidence, the first thing you do is you look at the evidence, you find out, evaluate what you have, what it is, and then you proceed from there, and the type of testing you would like to do is going to be the most informative and the most conclusive. And you have to evaluate each piece of evidence for that purpose.
And are you qualified to do that?
I believe I am, yes.
Does your training, in fact, qualify you to do that?
Yes, it does.
Now, are you also trained and experienced in determining how much volume of sample is needed for each test that you determine is appropriate to be performed on each item of evidence?
Yes.
Now, in this particular case, was it requested of you to determine whether certain items of evidence that were blood stains recovered from both the crime scene and the residence of the defendant, as well as blood recovered from certain items found at the crime scene and the defendant's residence, were sufficient in quality and quantity for subjecting to certain scientific tests?
Yes, we were asked to determine whether the evidence, our best estimate as to whether the evidence was appropriate for that.
And did you review also the number of tests, a variety of tests or range of tests that could be performed on each item of evidence in order to gain the maximum possible confidence in the results?
Yes, we reviewed the samples and made our best estimates to what could be done. Of course, there's never any guarantee until the tests are actually done, or you do actually start working with the evidence to determine whether that you're accurate in your estimate.
Now, did you in fact then review much of the evidence that has been recovered in this case?
Yes, most of it.
Tell us, first of all, for purposes of clarity, which items were you unable to examine for the purpose of determining whether a blood split could be given to the defense?
Okay, I'd like to refer to my notes.
Please.
Thank you. Okay, the items that were unavailable to us were items number 61 through 71.
Do you have any knowledge, ma'am, of which items those are?
I have some references to what they are. I don't have any absolute knowledge as to what they are or where they came from. I know what they're listed as.
What are they listed as?
Okay, item number 61, I believe, is a handgun.
A handgun?
A handgun, yes.
Let me just ask you this. Items 61 through 71,
Mm-hmm.
is it your belief, based on the information you have at hand, that none of those items contains blood evidence?
I'm not sure, because some of those items were recovered by detectives, I believe, and there's indicated, I know, on there some sheets and pillowcases and a towel with a broken glass, so I have no idea at this time.
Is it your information that some of those items listed in 61 through 71 came from Chicago?
That's what I presume, based on what they are. Assuming the detectives collected them, because most everything else that is available to us was collected and booked by our criminalists.
As a matter of protocol, let me ask you something for purposes of clarity, Ms. Kessler. Where can evidence be booked? Are there two places where they can go?
Well, there's many areas. The Los Angeles Police Department has several property rooms, including one that is adjacent to the crime laboratory and one that is in Parker Center, as well as one in many of the area stations. And evidence can be booked at any one of those locations.
Now, the items that you have in fact evaluated for the purpose of this hearing, where were they?
They're all booked at Piper Technical Center.
Which is adjacent to your laboratory.
That's correct.
The items that you were not able to examine, where are they?
They are booked and sealed in a vault at Parker Center.
So items 61 through 71 you were not able to look at.
And also items 88 through 90.
What about items 73 through 81?
73 through 81, we have those items, but we just received those late Friday and have not been able to evaluate them. That is the coroner's evidence. Some we evaluated, the clothing we could not at this time.
The coroner would not release them to you until last Friday?
That's correct.
Was that, if you know, in order to accommodate the defense in examining the evidence first?
That's what we were told, yes.
And items 88 through 90?
Those are booked at Parker Center. And I believe those are from Chicago based on the property report.
So those were not looked at.
No.
Items 91 through 93?
Those were just recovered in conjunction with a search warrant that was served on 6/28, and they were booked late yesterday, so we have not had a chance to review those items.
91 to 93, weren't those
Oh,
recovered?
I'm sorry, 91 through 93 were recovered from a Bronco, but they were also just recovered yesterday. Sorry.
In other words, was other testing being performed on the Bronco?
As
Prior to
far as
that?
I know, it was, and then there was some indication that there was possibly another search for evidence that they didn't want to make in the beginning, and so they went back a second time to look at the vehicle.
But the vehicle remained in police custody.
As far as I know, yes.
Your Honor, may I suggest to the court that leading questions not be asked of this witness unless absolutely necessary?
Your Honor, this is an expert witness who has the reports in front of her.
Expert testimony is not subject to the leading question objection. However, at this point in time, I don't believe she's actually giving you expert opinion. She's rather giving information concerning specific items of a background nature. The objection at this time is sustained. I'm going to ask you, please, with regard to her expert testimony, obviously she can, you can ask leading questions, but on these foundational matters, I prefer if you could refrain from asking leading questions.
Items 94 through 109. Have you looked at those items yet?
No, those were recovered pursuant to a search warrant on 6/28 and booked yesterday at Piper Technical Center, but we've not had a chance to review them for physical evidence.
And items 110 through 113?
Those are items that were booked yesterday also at Piper Technical Center, and those are items that were recovered from other items already booked. And they are trace evidence items.
Are those hairs that were recovered from something else?
They're evidence, including hairs and fibers recovered from property items, and I can tell you what those are one at a time. For example, item 110 was recovered from item 9. Item 111 was recovered from item number 27.
Wait, what item 110
was recovered from item number 9.
What's item number 9?
Again, I'll refer to my notes. I believe it's a glove.
And item 110, what kind of evidence is that?
Yes, item number 9 is a leather right-hand glove.
We have not received a list of inventory items beginning at 91 for which testimony has been offered this morning.
All right, the document that was provided to me, does the defense have that summary as well?
I intended to give the copy that the court has to the defense. If the court can allow us, we have another copy.
Please.
This information is contained in other discovery, but the list that is compiled was just compiled by this witness for her testimony. The information is all in possession of the defense, Your Honor.
Your Honor, that simply is not true. We don't have any information about what was recovered yesterday.
No, this is not pertaining to items that were recovered yesterday. The witness is testifying to items that were recovered some time ago from other evidence. This witness is describing right now trace evidence that was recovered from items that were seized from the crime scene. And the defense is in full possession of that information.
Your Honor, my recollection of the testimony of this witness is items 94 through 109 refer to items seized yesterday from a search warrant. And we have not received any of this information. We asked for it yesterday.
Your Honor, the people didn't have the information either, and none of the items seized yesterday will be the subject of any testimony in this hearing because no one's had a chance to look at it yet. It was so recently seized. And the property reports are presently being compiled. All this witness did was write down the numbers. There's been no attempt, no time to look at those items for any purpose whatsoever. The property report that will be put together with the return to search warrant will be given to counsel as soon as the people get it. At this time, I just asked the witness to jot down the item numbers so that it could be indicated to counsel what has and has not been looked at for future purposes.
All right, so for purposes of the hearing today, no determination whatsoever as to sufficiency of samples regarding items that were recovered in the execution of the search warrant a couple of days ago is being offered, correct?
Right.
Okay.
Your Honor, in that regard, my understanding is that as soon as the search warrant is executed, a return to the search warrant must be filed. And as soon as that is done, we would like to have the court order immediately to have those items listed and made available to us.
Your Honor, as counsel should be aware, the police have 10 days to prepare a return to search warrant, at which time the property report listing what has been seized is attached to that return, and the law will be complied with as it has been throughout this case.
Yes, they do have 10 days to file their return, and of course the continuing discovery that is occurring in this matter does require that those matters, of course, be turned over to the defense. And in the event that you do have that completed before the 10 days, I would ask you to turn that over to the defense as quickly as possible.
Certainly, Your Honor.
All right.
So with respect to item number 110 is your number for what?
Item number 110 is just a number given to trace evidence recovered from item number 9.
And that
That was a glove. And our policy is that whenever we recover trace evidence, that rather than just putting it in a bundle or a bundle with the original item, we book it as a separate item number. Now, that evidence was all viewed by the defense in my
trace evidence you're talking about as number 110, which was viewed by the defense last week, was what?
Hairs and fibers.
Recovered from a glove?
Recovered from item number 9, the glove, yes.
And number 111?
Was hairs and fibers recovered, trace evidence again, recovered from item number 27.
Which was what?
Item number 27, I believe, is a cap. I have to keep shifting back and forth. Yes, it's a cap. That was recovered from the driver's floor of the Bronco.
And again, that item was viewed by the defense last week as well?
Yes.
And item number 112?
Is trace evidence recovered from item number 37. That is a left-handed leather glove.
And what is the trace evidence recovered from that left-handed leather glove?
Yes.
What is the trace evidence?
It's hairs and fibers in this case.
Also examined by the defense last week?
Yes.
Item number 113?
Was hairs recovered from item number 38, which is a blue knit cap.
Did you say that was hairs recovered from a
Yes,
blue knit cap?
a blue knit cap and some fibers, yes, I'm sorry.
And that was also viewed by the defense last week?
Yes.
So, now with respect to those hair items, I'm going to come back to those later. Let's go back now and address the blood splits that have been requested. Now, based on your training and your qualifications, are you qualified to indicate to this court what volume of sample is needed for each test?
Basically, yes, an overall evaluation.
Now, with respect to items 1 through 60, and items 82 through 87, did you make a determination as to whether a blood split for the defense on any of those items would be possible after the testing of those items on all standards available would be possible?
Yes, we made an estimated evaluation of these samples and found that a few of them appear to be sufficient for a split after the whole battery of tests is completed. There's no guarantee until we complete those tests, however. Other than on the samples taken from the victims and the defendant, there's plenty of sample for a split.
When you say samples taken from the victims and the defendant, you mean?
Those are the standards. The reference samples, the whole blood taken from Mr. Simpson and the whole blood swatches, frozen swatches taken at the time of autopsy from the coroner's victims.
Now, can you tell us, identifying by item number, which ones you determined may, after we've completed our testing on them, may permit for a split?
Certainly. Item number 3, which is a cigarette butt, recovered from the street, would be tested, and there should be plenty for a split after we're done. Item number 7 is several swatches containing red stains recovered from a driveway, and it is possible, looks fairly good, that could have enough left for a split after the testing is done. Item number 12 also has several swatches of different sizes, and they are fairly dark red. And again, those appear to be a good possibility for a split after our testing is all done.
Item number 17?
Item number 17, as stated before, is a reference sample from Mr. Simpson, and that there'll be plenty of that available for a split. Item number 42. There is, again, several swatches, fairly medium to dark red in color,
and there should be enough for a split at the end of the testing. Item number 44, that's possible. Those appear to be very much weaker, but there are several swatches, and so there's a good possibility of a split on that item also. Number 47, there's plenty there. We pretty much have no question there'll be enough for a split when we're done. Item number 49, I'm sorry.
Can you say for certain that a blood split could be provided before the testing has been completed?
No, not actually. There could be something, this is our best estimate again, there could be something go wrong. There may be not as much white blood cells there as we need, and so we could be wrong. Again, it's a best guess. Without actually starting to extract the evidence and prepare preliminary gels on it, we can't tell for sure. Item number 49. There should be, again, appears to be plenty available for a split when we're done with our testing. Item number 50 is a little weaker, but has a good possibility for a split after we're done. Item number 57, it appears to be possible for a split after we're done testing. Again, as indicated earlier, items number 72 and 82, blood swatches from the victims, will both have plenty of material available for a split after we're done.
Blood samples taken from the victims.
Reference samples, yes. They're listed as coroner's samples. And those are the only items at this time that we feel fairly confident that when we're done, there will be a sufficient sample for a split.
Now, before all of the testing proposed to be done on all of the items has been completed, is there any way to know with certainty whether any of these items can be turned over, can be split and given to the defense for independent testing?
Not without doing the analysis, except possibly on the reference samples. But without doing the analysis, we don't know how much we would need, and therefore could not even begin to estimate how much they would need to have either.
In other words, leaving aside the issue of the reference sample, which I understand the blood samples we're going to have plenty of, with respect to the evidence samples, is there any way to know whether at this time, before the testing has been conducted, there will be sufficient material left to provide a blood split to the defense?
No, cannot give you a definite answer. Yes, that there will be.
Cannot be done.
Cannot.
But at this time, for sure, you can rule out certain items that you know would be incapable of providing a split.
Yes, there are many very, very small samples here that may only lend themselves to one type of test at best.
So the items that you've listed for us today, then, are possibles, but you will not know until the testing has been completed.
That's correct.
Now, with respect to hair evidence, did I inform you yesterday that the defense was making a request to limit the samples of hair taken from the defendant to one hair?
Yes, you did.
And what was your response?
Well, I was shocked at best. First of all, I said, "You got to be kidding," I think was my response.
And why was that?
Because it's impossible from one hair, to make any kind of determination microscopically for a reference standard from one hair to determine whether that's similar to other hairs.
What is the standard number of hairs required, or the method of retrieving sample hairs from a defendant in order to perform a comparison of those hairs to hairs recovered from a crime scene or item of evidence?
The method of retrieval is such that you take samples from all parts of the head, the front, both sides, the crown, and the back. And it's by pulling and combing, because you do absolutely need some of the roots, if at all possible. The second saying is that the recommendation in several articles, including that made by the FBI, is 30 to 100 hairs. And then you take a random sample of that 30 to 100. So they are suggesting that 20 reference hairs from each of the 5 areas, roughly making the 100.
Then let me ask you this. How do you make sure that you don't mix hairs taken from different parts of the head?
That's not important. You can mix them once they're taken from different parts of the head. It's just that the hair differs on different parts of the head, and you want to get an overall random sample, and then you take those and you get a overall picture of what the hair looks like, and then you compare it to evidence hairs taken, because you have no idea where those evidence hairs came from.
Right. When you recover hairs from a crime scene or an item of evidence left at a crime scene, you don't know what part of the head that hair came from.
No, you do not.
And with respect to, as a matter of public habit and custom, are the hairs recovered from the head of a defendant segregated by the area from which they were recovered for reference purposes?
We segregate them sometimes when they're taken. It's not an absolute necessity. It's kind of an individual choice on the examiner.
With respect to comparison and analysis of hairs using the test known as PCR, and that's for DNA, is that correct?
That's correct.
How many hairs would be required to be recovered from the defendant for the purposes of comparing his hair to evidence that was recovered from the crime scene?
Well, for PCR, we usually use the reference blood sample versus the crime scene hair. And as far as hair, it is possible to do PCR on one hair root. That's the minimum amount you must have, but there's no guarantee. There's some ratios, and I don't know the percentage offhand as to how many times that has to be done or how many times they've been successful with one hair. It all depends on how good the root is, the age of the sample, etc.
Then for the purpose of performing comparison, even using the DNA test known as PCR, would you say that it was an accepted scientific practice or procedure to use only one head hair if you were going to compare it that way, taking from the defendant to evidence hair recovered from a crime scene? Would that be an appropriate method to use?
No, I wouldn't compare hair to hair. For PCR, again, I'd use a reference whole blood, preferably.
But if you did, would you say it was an accepted scientific practice to use only one hair from the defendant for that purpose?
Well,
She's answered that question 3 times. She said, for DNA, we do not need any hair to compare blood to the hair.
You know, Your Honor, she hasn't answered my question, and this goes to counsel's representation concerning the fact that he claims his expert said we only need 1 to 3 hairs. And that's why I'm inquiring as to this particular topic.
Do you understand the question?
well, let me see if I can I try to attempt to?
Well, I can reframe it, actually.
Okay.
Can you tell us whether it would be proper scientific procedure to perform a hair comparison using only one head hair from the defendant to compare to crime scene hairs for any test?
No.
Have you ever heard of any criminalist who would advocate comparison of crime scene hairs to only one hair taken from the head of a defendant?
No.
All right, Mr. Shapiro, will you be conducting the cross-examination of this witness?
Yes, sir.
All right, and I did, at the outset, forget to ask the attorneys if you would use the podium. There are no microphones at counsel table. There is, however, a microphone at the podium, and that way everyone will be able to hear the questions.
Your Honor, may I refer court and counsel to page 14 of our discovery motion, item 29B, which basically asks for a curriculum vitae of all expert witnesses. We have not received that yet.
Do you have a copy of your resume?
No.
Would it be possible to have some, do you have that prepared at your office?
I believe it's in the computer, yes.
Would somebody be able to fax it over here to the building so that can be provided to Mr. Shapiro?
No, because they can't get to it. I'd have to do it when I get back.
Mr. Shapiro, do you need that before you're prepared to begin the cross-examination?
Well, Your Honor, it would save a lot of time rather than going through all of her credentials. And we'd like to examine that. We may be able to stipulate she's an expert, or we may want to contest that.
All right. There's no one else that has access to your computer that can generate that?
Call and try. I don't know who's there right now.
All right. Why don't we see if we can facilitate that in the quickest way possible? Are there any questions that you have related not to her expert opinion, that just to the foundational matters concerning certain item numbers, or would it be better just to wait until we can get to her background?
I think the background would be important to have first.
All right.
Thank you.
Okay. Then we will break at this point in time, and if you could get that as quickly as possible, I would appreciate it.
Your Honor, may counsel approach the court for purposes of scheduling only?
Yes. Do you want this on the record?
It can be on the record or off the record, just a personal...
All right.
reference to the
Then
court.
I'll see counsel in chambers with the reporter.
Yes,
Thank you.
I'll notice you have to be on the record. Yes.
All right, we're once again on the record, a case of People versus Simpson. The defendant is present with counsel. The people are represented. Mr. Shapiro, I assume that you do now have a copy of the curriculum vitae?
Your Honor, what I have is not the curriculum vitae, but a statement of qualifications.
All right.
That's all we have.
And Ms. Kessler, if you retake the witness stand. You've previously been sworn and remain under oath.
Yes, Your Honor.
Mr. Shapiro.
Good morning.
Morning.
Is it Miss or Mrs. Kessler?
Mrs. or
And-
Ms., whichever you prefer.
What do you prefer?
Doesn't matter.
Ms. Kessler, does your husband work for Los Angeles Police Department as a detective?
Yes, he does.
Your Honor, I think this goes to, I think it goes to credibility. I can make an offer of proof if you would like.
The objection is sustained. The motion to strike is granted.
Your Honor, may I inquire as to whether or not he is or has been assigned to the very division that's investigating this case? Would that be of relevance to the court?
You can ask that.
Thank you. What is your,
Overruled.
has your husband been assigned to the robbery homicide division, to your knowledge?
Yes, he has.
Is he still assigned?
Yes, he is.
And do you personally know the two lead detectives in this case?
I've worked with them for several years. That's,
Do you know them personally outside of work?
no,
Have you discussed this case with them?
just as pertains to the case and evidence involved in the case.
And have you discussed this case with your husband?
Not really, no.
You have provided us with a statement of qualifications consisting of 3 pages in the form really of check boxes. Is this what you consider your curriculum vitae?
This is the only thing that we have used most recent years since Prop 115. This is all I have available at this time. This is what we've been considering our CV, yes.
My question is, do you consider this your curriculum vitae?
I have used this type of statement for years. I used to spell it out in terminology rather than have check boxes, and just, it used to look more narrative, but it didn't go into much greater detail.
Prior to being employed by the Los Angeles Police Department, what was your work experience?
I worked for approximately 5 years in a private laboratory performing chemical analysis and biological analyses.
What part of that work consisted of DNA?
DNA wasn't being done until the last few years.
What part of that work concerned microscopic comparison of hair?
None then.
What part of that work consisted of serology?
None at that time, other than in my master's thesis.
What part of that work consisted of maintaining samples of blood?
None.
What part of that work consisted of collecting samples of blood?
None.
What part of that work consisted of preserving samples of blood?
None.
Now, you have authored one article, is that correct?
I authored one article, yes. I've been co-author on several others that aren't listed here.
And what is the article that you have authored?
It was, I have to read the actual title. The lab goes to the lab.
When was that published?
1982,
And you were the co-author on that.
yes.
Have you authored any articles?
No.
What did that article deal with?
That is about clandestine laboratories,
Drug cases?
yes.
Had nothing to do with serology?
No,
Have you published or co-authored any articles on serology?
no,
Have you published or co-authored any articles on hair analysis?
no.
You indicate your training in the discipline of hair. Is that how you refer to it, the discipline of hair?
Actually, it's hair is just like a fiber, so I guess it'd be hair and fiber analysis.
Let me refer you to page 3 of your statement of qualifications, Mrs. Kessler. You list there courtroom experience, discipline, hair, 1980 through 1986. Is that correct?
That's correct. That's the last time I testified on a hair case.
And up until that point in time, you testified approximately 35 times?
That's correct.
I don't see anything on your statement of qualifications indicating testifying regarding blood samples, or blood preservation. Is your qualification statement incomplete in that regard?
No, it's under crime scene investigation and preservation of evidence on page 2. I've testified approximately 55 times in crime scene investigation and preservation of evidence, and in each of those cases, or almost all of those, has to do with blood preservation and obtaining sufficient sample for analysis purposes.
When was the last time you testified in a court of law regarding the amount of a sample necessary for preservation for later analysis?
Oh, let's see, probably about let's see, when did I prepare this? Actually, the date changes automatically, so the last time I testified, and that was probably about 1988, 86.
Do you recall which it was, 88 or 86?
No, I don't recall. I really don't recall the year, so sometime between 1982 and now, but only once or twice since then, because I've been in management most of that time.
And how many times have you testified since 1976 regarding the amount of blood that is necessary to preserve a sample for later analysis?
Between 30 and 55 times. Almost all those cases listed on page 2 that refer to crime scene investigation and preservation of evidence are dealing with blood.
And you were specifically asked the amount of blood necessary to be preserved for later analysis? Is that your testimony?
I'm not sure if that was exactly what was questioned, no.
In fact, that was never asked of you before today. Isn't that the case?
No, that's not true.
Do you recall when the last time you testified to the amount of blood necessary for splitting was?
I don't believe I've ever been asked to testify to that.
Now, I notice in your statement of qualifications that you indeed attended a seminar on DNA. Is that correct?
Yes,
And that was in January of 1988?
that was one, yes.
And that's 8 hours?
That's one, yes. I attended several which are not on here. As I said, I was not prepared for this, so this is not up to date.
Well, it's dated the 24th, is it not,
I was
of
just-
this month?
As I explained, the computer automatically updates it, and I did not have time to go back in. There was apparently a rush to get this here, so.
Well, isn't that something that's standard for people who testify as expert witnesses to have a curriculum vitae that is current to date?
It's only required if I'm going to bring it to court, and as I stated, I don't testify much anymore, so I don't update this on a routine basis now. I keep track of my interests and what I'm doing, but I don't update the CV all the time.
When were you notified that you were going to come to court as a witness in this case?
Yesterday, or perhaps the day before, late at night.
When were you given information regarding this case? When were you given evidence regarding this case?
Well, I was never given evidence.
When were you aware that evidence was available during this case?
When the
That's
case,
irrelevant.
Oh, you can answer that.
whenever the case went down, there was evidence, but again, I did not expect to be involved.
You didn't consider yourself as a potential witness in this case?
No, I did not.
Well, the things that you haven't had time to add on to your statement of qualifications, let's talk about DNA. What additional qualifications do you have since 8 hours of a seminar in 1988?
I have spent many, many hours with experts in the field from private laboratories, including Cellmark, Life Codes. I have attended all the American Academy meetings for the past, since 1985, which is once a year for 40 hours a week, and I would say at least 2 days of that is always devoted to DNA. I also have attended all the ASCLD, as an ASCLD Board of Directors meetings twice a year for the last, since 1985 also, and there's always an update by the FBI and private laboratories on DNA analysis and what is required for that. And I have been instrumental in implementation of DNA in our laboratory as the manager, and so I'm very familiar with it.
Do you know who the scientist is that is responsible for the DNA subtypes that are being used in this case?
The scientist that's
Yes.
responsible, the person that developed it
Yes.
individually?
Yes.
No, not off the top of my head. I'd have to look that up.
I take it you haven't read any of the books that he's published on this subject?
No, I have not read extensive books on the subject.
And I take it that you haven't taken any courses that directly relate to DNA in a school atmosphere?
Except in college, and DNA was, barely mentioned as part of genetics and microbiology.
And when was that? I don't want to have to set a
That's
specific
quite all
date.
right, counsel. I'm not concerned about my age here. It was probably 1970.
And that was the last time you were involved in any academic setting?
Academic setting, that's correct.
Now, I understand that you list as your training the following things. How to turn your work group into a winning team, Los Angeles Police Department.
That's management training.
Okay, that has nothing to do with winning or losing a criminal case.
Not that I recall.
And then you've had 2 courses in management seminar.
Actually, that's an ongoing management seminar, as I stated earlier. As a member of the American Society of Crime Laboratory Directors Board of Directors, I attend management seminars at the FBI twice a year.
And you attend seminars regarding sexual harassment?
I've attended. There's always an update on that, believe me.
And you've gone to forensic alcohol supervisor school?
That's correct.
Do you consider yourself an expert in DNA?
Not in DNA. I consider myself an expert in preservation, collection, and evaluation of evidence for all types of tests.
Do you consider yourself an expert in serology?
No, not in today's current serology. Again, evaluation, and I understand it. I can review reports and I can review people's analysis. I would never try to do it at the bench, but I do understand it.
Do you consider yourself an expert in the comparison of hair?
Yes, I do.
And what scientific training have you had academically regarding the comparison of hair?
Well, there isn't really any academic training other than my master's program, in which part of the courses in criminalistics involve comparison of hair. And also the Macron School, Hairs and Fibers, that's one of the academic courses, and I've been trained on-the-job training in the FBI method of hairs and fibers analysis.
Are you familiar with a gentleman by the name of Dr. Henry Lee?
Yes, I am.
And can you tell us who he is?
He is a forensic scientist out of Connecticut.
And do you have an opinion regarding his qualifications in this field?
Not in hair examination, I have no idea.
What about as a forensic scientist?
I don't know if Henry actually does any bench work anymore, if he's like myself and he advises and oversees and reviews work and evaluates evidence. Other than that, I know he's like myself. He used to do a lot of bench work, and I considered at that time what he was doing as well as what I was doing, him to be an expert. He is also a member of all the associations that I'm a member of.
Is he a member of any organizations that you're not a member of?
I don't know.
Have you seen his 50-page curriculum vitae recently?
Objection, Your Honor. Counsel's testifying as hearsay. We have no evidence of that. If counsel wants to put it into evidence and call Dr. Lee, that'd be fine, but...
The objection is sustained.
If Dr. Lee is of the opinion that you only need one hair for DNA testing, would you agree or disagree with that, yes or no?
Objection irrelevant.
Sustained.
I'd like to now, Your Honor, direct the court's attention and the prosecutor's attention to the list of evidence, and I would like to, painstakingly as it may be, go through each item to see what tests were done, what tests are anticipated, and what the amount of sample is and how much remains.
Objection irrelevant.
I don't think it's irrelevant. However, do you have that information at your fingertips?
I'm sorry, could you repeat what you...
You testified there are 60 items of evidence. I'd like to first direct your attention to the items of evidence that relate to blood. And I would like to review with you each one of those items of evidence, what tests have been performed at your laboratory to date, and what tests you anticipate performing in the future so the judge can make a determination as to whether or not we will be able to perform the exact same test. What we would like, Your Honor, is this. If they have done serology and DNA, and there still remains a sample, we would like to do serology and DNA.
No, I think I understand where you're going with this. You want to know how much of a sample remains.
Exactly.
And what tests have been done, and if no tests have been done, you want to know that also.
Correct.
Okay.
Your Honor, I think that perhaps it would be a lot more efficient if counsel would simply look at the documents he was given today, which indicate exactly what tests have been done and not done, and with respect to having the court determine whether or not further testing should be done, or whether sufficient volume exists to provide a split at this point in time as to any piece of evidence, how could the court do that? That's a matter for expert opinion.
Well, that's correct. And my understanding is the defense apparently intends to present some expert testimony on that issue.
Well, that was not my understanding, and I expressly asked Mr. Yeoman last night when he called to ask me what the order of witnesses would be. I asked him what witnesses he intended to call today, and he informed me there were none.
Mr. Shapiro?
Your Honor, I think we will be able to satisfy the court from this witness through our cross-examination that the tests that have been done, samples remain, and those samples will be enough for us to duplicate those tests in almost every area.
All right, well,
In other words, counsel is indicating that he is not going to call any witnesses, expert or otherwise, pertaining to this blood split issue.
that seems to be the general import of what you're saying. Is that correct?
Your Honor, that is a general import. Obviously, we have the right to call witnesses. We do not anticipate calling witnesses, but as the court well knows, depending on the answers that are given, we will make that determination at an appropriate time.
All right.
Counsel is in possession of the information he is seeking in the list that was provided to him this morning. It indicates what tests have been performed. If counsel needs to inquire further as to what tests are planned, that could be done collectively as opposed to item by item.
Well, I'm not going to tell counsel that he has to examine in a collective fashion. You know, you can go item by item. If you have this particular information, it might be helpful if the witness has it also to refer to it, because there's so many items by number. I don't want to get into the results, however, of any of these tests.
I will not ask the results, and that is not my intention, Your Honor.
All right. You may
Thank
proceed.
you. Let's, may I direct your attention to item number 1? And just let me know when you have an opportunity to focus on that.
I'm fine.
Item number 1 contains 2 bindles,
No, it contains 2 swatches.
2 swatches. Okay, I wanna
I'm
make
sorry, item 1 is 1 bindle containing 2 swatches, and item 1C is a swatch, which is just a control sample.
So you would say that that item number 1 has 2 bindles that are composed of a swatch and a control.
No, I'd prefer to keep them separate because it'll just be confusing if we could stick to item 1 and then 1C separately. Item 1 contains 2 swatches.
And was any analysis done on item 1?
Not yet.
How much evidence is contained in item 1?
There is 1 swatch that's approximately 2 millimeters square and 1 swatch which is 1 millimeter square.
Where was that found?
Oh, yeah, I'm sorry, I thought we were going to deal with just quantity of evidence, not location.
Mr. Honor, counsel is in possession of a property report that indicates where all of these items were found.
I don't think it's necessary at this
Very
point in
well.
time to know where that
Thank
was
you.
located.
Thank you. When do you anticipate analyzing that?
Objection irrelevant. Counsel wants to know at this point what this witness's opinion is with respect to the availability of a blood split. When the test will be performed in the future is irrelevant to that determination. I think that counsel should be confining his questioning to matters that are now an issue. And that would be what tests have been performed, what tests are planned, and what volume she anticipates will be available for the blood split, if any.
I don't think that there's a problem asking about when a test is going to be performed, because that, I suppose, would be relevant in terms of knowing when there would be sufficient samples, since the witness has indicated that apparently she won't know until the tests are actually performed on any of these items whether there's going to be enough for a split. And we'll just be back here again doing this in the future to try to find out this information. If she knows when a test is scheduled at this point, she can tell us. If she doesn't know, then that's fine.
Well, my point is, Your Honor, it doesn't matter, because with respect to all of the items, the few items that she's indicated may be capable of providing a split, she won't have the answer for that either until the testing is done. So we're going to be back here anyway, because one way or
Well,
another...
I understand that. If within her knowledge, at her fingertips, here on the witness stand, she happens to know when a particular test is scheduled, and fine, she can answer that. If she doesn't, we're not going to go and research it anywhere. All right, Mr. Shapiro.
Yes, you may answer the question. if
We
you
have not
recall.
had a chance to get back to this at this time and schedule the testing. We spent a lot of time evaluating these samples, and that's about all we've had time to do.
When do you anticipate testing it?
Probably within the next, they'll be either sent out or be done in our laboratory within the next, as soon as it can be arranged, probably. It depends on our schedule. We have other courts, and so I'd say within the next 3-4 weeks.
What is the criteria for sending it out?
It depends on whether we believe that we can do it in-house. It depends what we're going to do on it. Obviously, if it's RFLP that we think can be done, it's going to have to be sent out. We don't do that in-house.
Is that the only thing that you would send it out for?
No, not necessarily. We also, if we're going to send it for RFLP, it's a good chance that we may decide to send all of it out for PCR, and that determination hasn't been made yet. Conventional serology, if it's possible, would be done in-house.
What test do you anticipate doing on this sample?
On this sample, it appears that, based on the small size, that we would be best suited to just attempt PCR and possibly limited conventional. But we'll try as much as possible. It doesn't appear to be enough for RFLP.
Limited conventional refers to what?
Limited means we will pick the best markers out of conventional serology, whatever they may be, the most discriminating markers, and just do those. We probably cannot do a full battery of conventional serology tests.
After the serology test is done, how much of that sample will be consumed?
Probably most of it will be consumed.
Then
It'll
we'll-
be extracted. The extract will still remain, but the sample as is, the claw squares will be consumed.
Part of the sample will remain, however.
The extract, which means someone has already worked on it and developed an extract.
Will any of the original sample be maintained?
No, can't.
So after serology, you are left with just an extract.
That's correct.
How much of the extract will be left?
I have no idea.
What do you anticipate based on the
It's
size?
not a volume at that point, because it depends on the concentration of the sample, and you can concentrate that down into essentially nil. So it's a concentration more than it is a volume. The volume is sort of irrelevant. It's more concentration of sample than volume. I can dilute it up and give you a gallon of extract, which means nothing,
Would there,
because it'd be so dilute you couldn't use it.
in your opinion, is there enough material here for both your laboratory to do a serology and for a sample to be given to independent laboratory for serology?
No,
So your opinion is there will be none left for any PCR test?
that's not what I said. I said there wouldn't be enough for us to do our work and someone else to take original sample from scratch and do any kind of serology testing, whether it's PCR, ABO, RFLP, etc.
Let me ask you regarding this PCR, that's a DNA test, is that
Yes, it
correct?
is.
And are there false positives in that?
Objection irrelevant.
Sustained. I don't want to get into the
you.
efficacy of various tests at this point.
Thank you.
Your Honor, may I
Let's-
make a suggestion to the court?
Yes.
This is going to take hours in the manner in which counsel is proceeding. And I don't know that evidence is required to be taken in this manner. Counsel could sit down with his expert and talk to this expert, who would be delighted to share all of her findings with counsel and any expert counsel chooses to have with him, so that he can understand what her position is. And then we could frame a stipulation as to the nature of her testimony. This is going to take all day in the manner in which counsel is proceeding. And I don't think it's going to assist the court any in being able to determine its ruling.
Your Honor, with all due respect, I am representing a man who is charged with 2 counts of first-degree murder, where the people may be asking for the death penalty. And if it takes 2 hours to determine whether or not there'll be enough of a sample for an independent evaluation, where we believe samples can be contaminated, where false positives are possible, and where errors can take place in laboratory procedure, I don't think that's being excessive at all.
Your Honor, I take exception to the manner in which counsel has characterized my response. I am making a suggestion to counsel that would allow him to have much more information than he's going to obtain in the manner in which he's proceeding. If he wants the information so that he can make a determination as to how he wants to proceed with the evidence and what he wants to argue to the court, what I am suggesting would allow him to learn far more than he will in this manner. He needs an expert at his side so that he can understand what this witness is telling him, and the manner in which he's proceeding will not permit him to do so. So I am actually offering him the opportunity to learn a great deal more than he is at the current time. I'm trying to assist counsel in being more efficient and more effective.
We certainly appreciate that.
Mr. Shapiro, you know, I'm going to allow you to
It will not be
present
that-
your motion your way.
Thank you. It's not going to be that time-consuming. We've been here since 9:30, and so far I've been allowed to ask one question.
Well, I
on
think
this-
you've
on
asked a
this
few
evi-
more.
Well, on the direct evidence. There's 60 items, about 30 are blood, and I think the responses should take less than a minute. So if we don't have any further interruptions or suggestions as to how we should present our case. Perhaps we can finish this.
Excuse me,
I don't think, excuse me, I don't think that's necessary from either one of you. So let's just proceed.
Thank you. The next item of blood that you have listed is item number 4. Is that correct?
Well, if you're referring to simply swatches containing red stains that appear to be blood, or that tested preliminary positive for blood, yes.
That's what we're referring to.
Okay, number 4.
That's item number 4? Would you describe item number 4, please?
It's one swatch that is 8 millimeters square. Approximately square. This is all an approximation on these measurements.
Have any tests been conducted on that to date?
No.
Do you anticipate any tests being conducted?
Yes.
When do you anticipate tests being conducted?
My answer on the testing would all be the same. If overall, maybe that would help. If
No,
we test-
I'd like to limit it just to this item,
Okay.
because this has a different quantity than the first, does it not?
Well, yes, but your battery of tests proceed in the same manner. And the extract on all of them has to be done first, and it's the same extract that's used for both PCR and RFP, so.
If you have no strenuous objection, if you could address item number 4 as a separate item, I think
Okay.
that would be helpful for us.
That's fine. I'm just trying to make it less confusing for everyone.
Thank you.
Could you repeat where we are?
Do you recall the question?
No, I do not.
Regarding item number 4, do you anticipate doing blood tests on this?
Yes.
What blood tests do you anticipate doing?
It appears to be enough to do, we hopefully to do both PCR, some conventional serology, and possibly RFLP, which would consume the sample.
If you just did serology, would there be enough of a sample left for an independent laboratory to conduct a serology test?
Well, serology, to me, includes DNA. So serology, DNA is part of all of it. Are you talking about conventional serology?
Let's get our terms correctly. Conventional serology is blood typing, is that correct?
Conventional serology is genetic markers, as is DNA, if you will. They're all genetic markers.
Let's start with the first test that you would anticipate doing and use your terms as to what test that would be.
I'm assuming, what I think we would do here first would be to attempt to do DNA, and then, if there's any remaining, do conventional serology.
If you did DNA first, do you anticipate, is there enough to do DNA?
Well, I indicated that RFLP, which is the most sample-consuming DNA, as opposed to PCR, which requires less sample, that we would consume the sample.
You haven't done RFLP on anything yet, have you?
No.
All right, so let's go with what you've done so far. So far, you've done serology on samples, and you've done PCR on samples, is that correct?
That's correct.
Do you anticipate doing serology on this sample, yes or no?
Only if there's sufficient sample.
Do you know as an expert witness whether or not the quantity you have is a sufficient sample for serology, yes or no?
As I indicated before, if we only did serology, yes, there's probably enough there to do only serology, but we would want to do RFLP first.
Would you just please answer my questions?
I'm confused.
Argumentative. The witness is attempting to answer his questions.
All right, ask your question again,
Thank
Mr.
you.
Shapiro.
Do you have enough of a sample to do standard serology, yes or no?
It appears we do.
If you did standard serology, would there be enough of a sample remaining for an independent laboratory to do serology?
Objection irrelevant. Your Honor, this is the point. We intend to perform serology, RFLP, PCR, polymarkers, every test available on each piece of evidence. And the only relevant question is whether after the completion of all of those tests, there will be sufficient evidence left for a split.
All right, the objection is sustained.
May I be heard on that, Your Honor?
Yes?
Based on the records we have received, the following tests have been done.
Have already been done?
Have been done by LAPD. Serology and a DNA test known as PCR. They have done no other test. And I've asked the witness this, and she has acknowledged that. What I would like to establish for the record is this. For those that have not been done yet, just go piece by piece. If you do serology, would there be enough for us to do serology? If you do PCR, would there be enough for us to do PCR? If you do other tests, would there be enough for us to do it? To make a record, because if these samples are consumed and we want to contest the fact that possibly exculpatory evidence existed, that we were deprived the opportunity of exploring, that should be part of the court record.
Your Honor, and it's irrelevant to our consideration. That is exactly the point. I don't think counsel understands. We have a battery of tests to which this evidence will be subjected. The question to be answered is whether or not after the tests are completed, they're sufficient for a split. That's the question, not whether after each test is completed, because counsel has no right to dictate to the prosecution the manner in which a case is investigated. We will subject the evidence to every test available and every test possible, and at the conclusion of those tests, if there is sufficient left for a split, we will be delighted to share it with counsel. We've made that clear. And this expert is only here to testify as to whether or not after the conclusion of all of the testing we deem appropriate, such amount will be left over. That's the only thing, not after each test. After each test makes no difference.
All right, Mr. Shapiro, I agree with the prosecution on this point, because I'm not in a position, I'm not going to put myself in a position to say that they can or cannot perform a given test on a given sample. And I don't think that's what the court's position should be.
Your Honor, I want the record just to be clear that we are requesting samples of all material relating to blood that have not yet been tested for our own testing, and I will leave it at that.
Okay, and I think that record is clear.
Thank you very much, Your
Let me
Honor.
also make the record clear then, Your Honor, that I have repeatedly advised counsel that I am going to make every single test ready for observation to him and to his expert. Every test performed can be observed in every step of the process by his experts at his choice. And if there's some question he has or concern about buffers or solutions being contaminated, we will be delighted to provide a split of any buffer or solution that is being used in the conducting of any test. So counsel is going to be allowed to examine every piece of evidence, observe the testing process to make sure that evidence is appropriately handled. And I want to reiterate that invitation on the record once again.
All right, and I think the record is clear on that also.
Thank you very much, Your Honor. The next item that blood was found is item number 5, is that correct?
That's correct.
And would you, have you done tests on that item or not?
No.
Next item where blood was found is item number 6, is that correct?
That's correct.
Have you done testing on that?
No.
The next item where blood was found is item number 9, is that correct?
No, I believe number 7.
Number 7? Okay. Have tests been done on that?
No.
What about number 8?
No.
Was blood found in both of those?
Yes.
What's the next item where blood was found?
Number 9.
Has testing been done on that?
Yes.
What was the first test that was done on item number 9?
The first test, because the sample appears to be very weak, was PCR.
Is there anything remaining of that sample?
The glove gives quite a bit of positive area for blood. You cannot see it, you cannot differentiate how much is there because of the leather. And until we actually extract it and work with it, we don't know. Yes, there's some remaining, we don't know how much.
Is that enough remaining, in your opinion, for an independent laboratory to conduct their own investigation?
Not to split it this time, no.
Is there enough remaining for an independent laboratory to conduct their investigation, yes or no?
Objection asked and answered.
It was asked, but it wasn't answered.
Do you know?
Well, I have to clarify this. If you mean, we're not done testing. So, do you mean at this time or when we're done testing?
At this time.
At this,
Objection irrelevant.
Sustained.
What additional tests do you intend to do on this?
we're going to do everything possible, and again, until it's extracted, I believe we'll even try for DNA, RFLP DNA, but we're skeptical that there'll be sufficient there for that.
The next item I have, and correct me if I'm wrong, is item 17 where blood was found.
No, actually number 11.
11 and 12? You have not analyzed yet, is that correct?
No.
Next
I'm sorry, 11 we did not test, 12 we did.
12 you did test.
Yeah, I didn't hear you say, I almost thought you didn't say 12 because I thought we were going one at a time.
And on 12, What test did you perform?
PCR.
Is there any sample left on that?
Yes, there is, and we're not completed with our analysis yet.
Will there be any sample left, in your opinion, when you complete your analysis?
Objection irrelevant.
Well, you're referring to completing all analysis, is that correct, Mr. Shapiro? in your
Yes.
question? Overruled, you can answer that.
I believe I answered this earlier. I felt that there would be a possible sufficient amount when we're done, but we won't know until we're done.
The next item where blood was found is item 17.
Actually, number 14,
There was an analysis done,
yes, PCR.
and the sample has been depleted.
Yes, it has. It was very small.
Now, you say an extract was saved.
Yes, we saved the extract.
What
We
does that
still have
mean?
That means the portion at which you're concerned about contamination, which is in the extraction process, or at least one of the processes involving DNA PCR, we extract the sample. We still have what's left of the extract. You don't need all the extract, but
Is
you
that a-
have to extract the whole sample.
Is a portion of that available for us?
We're not done. We may try to do some more with that, including polymarker. We'll send the extract.
Do you anticipate a sample will be left for us?
Probably not, because again, it's a very, very weak, small stain.
The next item where blood was recovered.
Well, 17 is the reference blood.
Okay.
That wasn't found there. That's a reference known blood.
Next, where blood was found at the scene. At one of the crime scenes.
Well, item 20.
What about item 18? Shoes, was any
Oh,
blood
no,
found?
no, there wasn't any. That's the test. We did a search for blood, didn't find any. I don't know if we're getting into that.
All right, the next item that you have,
20?
has that been tested yet?
No,
21,
not tested.
23,
22, not tested.
23,
23 PCR, plus the extract remains, and we intend to do the same with that as all others.
you don't, right now, does a sample exist? For reanalysis of PCR?
There's a small amount plus the extract, yes.
24,
No, not tested.
and next item,
25, we did PCR.
is there a sample left?
There's a very small amount of sample left, about. Actually, this is a small amount of fibers with a small amount of stain, and that's like, kind of like the glove. It's difficult until we extract it to know how strong it is.
Would that be available to the defense?
We don't know until we send it out for polymarker and some of the others. The extract will always be available. Whether it's sufficient for testing, I don't know.
Next item that you recovered
26.
regarding blood, that has not been tested yet?
No.
Next items,
28 are some threads. The sample's so small, it's not even what I consider a swatch. It's small, just 2 or 3 little cloth threads with red stain on them. It has not been tested.
next item is 29,
Correct?
that has not been tested?
No,
Next item is 30,
it's not been tested.
31,
PCR only, and the extract remains plus 1 small square, and we don't anticipate any of that being left except the extract.
at the present time, though, there remains sample.
That's correct. As you can see in the column, it indicates what's still there, and that's your 2 by 3 millimeter piece.
Next item,
Item 32,
has that been tested yet?
no. And there are several little threads.
Next item is item 33, carpeting.
Item 33 has has blood in several very small areas of some pattern resembling possibly a shoe print. And so we're holding off on that till we can decide how to progress and develop and look at the shoe print as well as the blood without losing either one.
Well, of
We
course,
did do,
what tests have been done on that?
we did on a separate little stain of one thread, we did PCR.
Is the same size sample available for the defense?
It's threads all over the carpet. You know, it's a carpet with a small little spatters of stain on them.
Would that be available to the defense?
Not at this time. I think it's very weak, and we haven't done the shoe print either.
Item 34 you have not analyzed yet?
And we did PCR.
You did?
Mm-hmm.
And
That's correct.
is there anything left on that?
There's a 2 by 3 millimeter piece that we have yet to continue with.
Is that enough for the defense to use for independent analysis?
Well, I don't know because we're not finished. We're not finished on any of these, actually, except the one that was consumed. We probably can't do anything more on that, but we're going to attempt to anyway.
At the present time, does there remain enough for a sample for reanalysis?
Yes.
Thank you.
Objection, that's irrelevant.
Sustained.
Next item.
May I just have a continuing objection to all of these questions concerning the request for whether there would be sufficient split after 1 or 2 tests before all the testing is completed. And counsel keeps going back to this, and I'm getting tired of objecting to the same thing. The court keeps sustaining it. He's asking the irrelevant issue, which is after each test, if there's going to be enough left. The question is, after all tests, is there enough left?
Ms. Clark, if you do have an objection, you're just going to have to make it question by question. Thank you.
Next item, please. With blood.
Number 37
That's a glove?
is a glove, and there appears to be stains on it that we have not tested yet, but they appear to be blood, and I'm sorry, they were preliminary tested positive for blood.
You know the size of that sample?
It's very small. There's a few drops.
What test do you anticipate?
As many as possible. Probably can't do RFLP, but we are going to certainly have it evaluated further.
When do you anticipate doing that?
We're going to begin early, probably Monday, determining who's going to do what testing.
Is there a standard laboratory that LAPD uses for independent testing?
No, there's not. Well, there's more than one we have. We use 2 or 3 labs for different types of testing.
For RFLP, who do you use?
We most often use Cellmark.
Next item, where any blood material was found.
Number 41, I believe. We did PCR.
What was the size of that sample?
There's there's several little swatches. There's 3 of them, but they're very weak.
Do you anticipate doing any more?
We're going to try to do polymarker, probably.
Next,
That's our hope, yes. We're going to attempt to do that.
next item.
Number 42, PCR has already been done.
Do you have the results of that?
Objection, irrelevant.
I don't think we've gotten that yet. I just want to just check. It was just for information only.
Okay.
Any sample remains?
All right, she's withdrawn her objection. Do you have the results on that PCR on number 42?
I don't know if I have them here, but I do know that I gave them to the defense last week at that same meeting.
My notes don't have the accuracy of that result down. Any sample,
Sorry, Ron, I didn't understand.
we'll withdraw the question. Any sample remain of that?
Yes, that's one of the ones that we're hopeful after testing, after we complete our testing, that there may be some available for the defense, but we're not sure.
Next item.
Number 44? Oh, I'm sorry. I'm starting to skip to what we already did. I'm losing track in this melee of samples here. Number 43, there are 4 swatches, and although there's 4, they're weak in color, and we anticipate that the entire sample will be consumed when we're done testing.
Next item.
Number 44, there are several swatches, and it's possible, we're hoping there may be some left when we complete our analysis. We haven't done anything, and we're not done.
Next item.
Number 45, we don't anticipate any being left. We have not tested it.
Next item.
Number 47, we have done PCR. We feel that they're, hopefully, based on what's there now, when we're done testing, that there'll be some left. Can't guarantee it, but looks promising.
48?
48. Probably will not be any left when we are completed. We have done PCR.
49?
49, we have done PCR and conventional and plan on RFLP. It's ready to send out.
50?
And, oh, by the way, on 49, we anticipate, that's one of the ones we anticipate there'll be enough left, hopefully, presuming everything goes well for the defense. Number 50, possibly. It's a little weaker than number 49, but there may be some left.
Number 51?
Number 51, we haven't done anything, and we don't anticipate any being left, though, when we are completed.
Number 52?
We've done PCR, and we feel that RFLP will consume the sample.
Is the next number 54?
Yes. Number 54, we have not done it. There's several little swatches, but we feel that RFLP will consume the sample.
Number 55?
Not tested. It's very, very small. Feel that there's not enough for RFLP, and that PCR and conventional, maybe, and polymarker, of course, is part of the PCR technique, will be all that'll be done on that one.
Number 56?
None left, but we feel RFLP will probably consume the sample. So that means RFLP and PCR.
Number 57?
That's 57 is a label found on a walkway, I believe. I made a separate note of this. It's difficult, again, because of the label, to say how strong the stain is and how much interference from the label. But assuming everything goes well, there may be enough left when we're done. We haven't done anything with it yet.
And 59 and 60 are coroner samples.
That's correct.
Does that complete the blood that's been submitted to you to date? That you
No, you
inventoried?
also have number 72, which is a coroner sample.
What else?
Number 82, which is a coroner sample.
Anything else?
We have not, yeah, any of these were in the column that indicate split, where I've written yes or no. That means we may do something with them. Number 84A, we've examined the nail scrapings, and we think that possibly, there won't be any sample left when we're done, but possibly we may be able to do PCR and 1 or 2 conventional tests. And 84B, these are the left and right hand nail scrapings. Same thing. 84C, the nail clippings. There won't be any left, but we may be able to do PCR and conventional. Number 84D are the right hand nail clippings, and there may be enough. It's even questionable. There may even be enough there to do RFLP, but we don't anticipate anything being left when we're done. Number 85A are some scrapings we received from the coroner that they scraped. We'd have to refer to their report. We believe we can do some PCR and conventional again, but don't anticipate enough being left. And 85B are some scrapings again, and anticipate PCR and possibly some conventional, and don't anticipate any being left over for the defense.
Does that complete the blood?
At this time,
As to the origin of those hairs.
no, we have not. We don't have a hair sample to compare those hairs to yet. Oh, I'm sorry, you just want a, did you want a body origin?
Yes.
Okay, I don't have that with me. I don't know if I gave that to, it's in process, and I don't know if that's one of the completed reports that I brought with me last night, which I know the prosecution hasn't had time to review. And
Have you determined those to be Caucasian hairs?
I can't tell you that without referring to the reports.
Can you look at the report?
I don't have it with me because no one has reviewed it yet, and I know you don't have it.
Your Honor, I was just provided this this morning. This is a package for counsel pursuant to the request we made when we were last in court. And I'm going to turn it over to counsel and give you an opportunity to look at it. I haven't seen it myself. We all just got these packages. So I'd ask counsel to acknowledge receipt of it on the record.
And that package is from the crime lab?
Yes, it is.
It's from the crime lab. If the court recalls, last time we were in court, we promised to turn over the records requested verbally, and I just got them. I'd ask that counsel sign for them where it's indicated and date it, and he can take possession, and then I hope he'll get fined at some point later today.
And just so if I may interject, what is not there is the protocol. We're still copying those. Those are volumes that we hope to have them early next week, Monday or Tuesday.
If you could inform the court what you mean by protocol.
The protocols for DNA and the proficiency testing for DNA, the PCR, and also conventional serology.
Does that have anything to do with the results or testing conducted in this case?
Not, it does, but it's not, we haven't talked about it here today.
No. The point being, that's a protocol you follow in all cases, is that right?
That's correct.
Not just for this case?
That's correct.
Your
Mr.
Honor,
Shapiro?
I wonder, based on what the court indicated the schedule would be, if we might take a break so we can review these records before we continue questioning. I anticipate very, very limited questions, only on the remaining four hair samples, and the amount, and for preparation so that the records can be looked at over the break. We'd like to know the number of hairs, whether they are follicles or shafts of hair, where they were found, and how many of them there are.
Your Honor, perhaps the reports that counsel has been given indicate all of that. And if that's the case, then...
Right, and if that information is contained within what you have, then you're going to have the answer to that.
Yeah, if we do. If we don't, those are things we'll be questioning.
Well, if you haven't got the report there, then I can't officially because it hasn't been verified. That means those items aren't done yet, not completed. We're still working on them.
All right, well, you'll have to determine that, and maybe you can sort of confer, if you need to, off the record with regard to some of these items. I don't think it necessarily has to be part of this motion that we're dealing with.
Thank you very much.
All right, then we will break at this time, and yes.
I'm sorry, Mayor, just one more. We received this from DTE. It looks like it's a response to a case taken, and it has been delivered to me by the clerk in a sealed condition, which is a matter in which it was delivered to her. I take it. Yes. And I'm going to ask to open it now on the record in open court so the counsel can observe the opening and the contents of the envelope, if I may.
Yes.
Thank you.
Your Honor, can this possibly be done in the appropriate manner?
This is the appropriate manner, Your Honor.
Well, I don't know that it has to be on the record.
Seems like a little bit of grandstanding, but
If the two of you-
maybe it
Excuse
isn't.
me, I can't believe I heard Mr. Shapiro say that. I'd rather conduct everything on the record, Your Honor, in open court.
All right, then open the envelope. Go ahead.
For the record, reflect that I have now broken the seal, opening the envelope, and I've retrieved what appears to be a one-page letter I'm going to show to counsel.
All right, Ms. Clark, my clerk Alicia informs me that that came accompanied by another larger packet of records which she's holding there, which you'll want to review, and I would really prefer that you, if possible, can review those records off the record.
Oh, I'd be delighted to review them off the record. All I want to indicate now is that they're in a sealed condition and that we may open them and duplicate them for counsel.
Assuming that both sides are agreeable to that.
That's agreeable, and that's the proper procedure.
Fine, thank you.
Excuse me, Your Honor, I don't think I've engaged in any improper procedures thus far, and I still appreciate counsel's editorial action.
All right, now, today only, because of certain matters that do not concern the rest of you, we are going to be breaking until 2 o'clock. I anticipate the following schedule, and I assume that most of you have been advised of this. And that is that the court intends to start at 9 o'clock and go until 12 with a 15-minute break somewhere during the mid part of that morning session. The court intends to under normal circumstances, continue with the proceeding at 1:30, with a 15-minute break somewhere around 3 o'clock or so, and concluding the proceeding at 4:30. That's what I anticipate, and that's a schedule hopefully that we'll be able to abide by, generally speaking. I'm going to ask everyone's cooperation with regard to these breaks that we take, the 15-minute breaks. I would very much like to see them remain 15 minutes as opposed to 20 minutes, 25 minutes, 30 minutes, 40 minutes. And so it's really going to be up to you folks to make sure that you are back in your seats and all the necessary counsel and so forth are back so that we can keep this matter moving along. So I would request the cooperation of everyone so that we can handle this matter as smoothly as possible. So at this point in time, we will be in recess until 2 o'clock. We will conclude this motion hopefully shortly thereafter, and we will begin with the other motions, including the motion to suppress at that time.
Thank you very much, Your Honor.
And I guess we can continue with the witness, Ms. Kessler.
May I turn over some discovery while we're waiting for her to come in?
Yes.
Pages 539 to 614, I'm handing to the defense counsel now. Copy of the SDP, which is the original which I returned to the court clerk.
We can acknowledge on them.
Yeah, the original. And I'd like to indicate to the court that I've given a copy to the court for review, an article on proceedings of the International Symposium on Forensic Hair Comparison. I gave a copy of this to counsel this morning. I'm specifically directing the court's attention to page number 11 on it, be the second paragraph in, where it's indicated that it is recommended that a known
Your Honor,
hair sample.
I'm going to object to reading this. This is a document that's a hearsay document stated June 25th, 1985. Thank God, we should have some material a little more recent than 9 years ago. There's any testimony that should be from the witness stand from the prosecutor.
All right, is Ms. Kessler prepared to testify in some fashion concerning this particular document?
Yes, ma'am. And
I'll wait until she refers to it specifically.
As I understand the law, Your Honor, an expert is entitled to rely on articles and periodicals, and that kind of hearsay is admissible through the expert testimony, and I was simply trying to assist the court in directing its attention to the specific area that is in question now.
All right, thank you.
apologize, Your Honor. It would appear the witness may have gone upstairs instead of coming straight to the court. Should be very much.
All right, Ms. Kessler, if you could retake your seat on the witness stand. You've previously been sworn and do remain under oath.
Yes, Your Honor, thank you.
Mr. Shapiro.
Mrs. Kessler, the information that we have just reviewed that was handed to us just before the new recess consists of a one-page document dated 6/29/94 that lists 4 items as hairs and fibers. Do you know which document I'm referring to?
Not off, no. Could you tell me the item numbers?
May I approach the witness, Your Honor?
Yes.
Oh, this is a property report, yes.
You familiar with that document?
Yes, I am.
Are there any other documents that have been prepared to your knowledge that relate to the hairs that were removed from items 9, 27, 37, and 38?
Yes, in that same package, along with that document, there was a report, or 2 reports, on hair items in regards to those property items booked.
May I just have a moment to get those, Your Honor?
Yes. Plus, I also was able to review and complete for our hair analyst 2 more reports on 2 more items of hair that we discussed earlier this morning that I said were awaiting my approval. And I have copies here.
So you're indicating you have some additional discovery for both counsel?
Yes, I do.
All right, Mr. Shapiro and Ms. Clark, do you want to approach the witness stand and pick up your copies of that?
Thank you, Your Honor.
Okay. Those are yours. And those are yours.
Thank you very much.
Thank you, Your Honor.
All right, thank you.
May I just have a moment, Your Honor?
Yes.
Could you summarize for us, please, the number of hairs that you recall were found in item number 9?
I believe you have the copy of the report. I'd have to review that.
You don't have that?
No, I don't have that one.
Let me give you all these copies, and then maybe we can work together.
Sure, that's no problem.
If you could keep your voice up, yes. Just to remind me, is item number 9 the glove?
Yes.
Thank you.
And item number 19 were items removed from number 9.
Thank you.
Just let me make sure of that before I say something wrong. Yes, item number 19 contained hairs and fibers removed from item number 9. So this report here, first report, is referring to item number 19, and in that item there were 3 human head hairs, blonde in color, and they ranged in length from 3.5 to 29.5 centimeters and exhibited predominantly Caucasian characteristics. They also exhibited indications of possible chemical treatment, bleaching. And none of them had roots. And then there were also several fibers and animal hairs, which we haven't had time to characterize further at this time.
Would you be able to give us the same summary, please, for item number 27, the cap that was found on the driver's floor of the Bronco?
Surely. Item number 111 contained, the new number, item number 111, is the hairs and fibers removed from item number 27, the cap. And that contains, among the hairs were 6 human head hairs ranging in color from brown to black, ranging in length from 1.1 to 2.2 centimeters, and exhibiting predominantly negroid characteristics. 2 of these hairs have intact roots, and the remaining 4 hairs do not have intact roots. And then it goes on to talk about several fibers and animal hairs, which we have not characterized at this time, and some insect activity, which is...
Regarding the 2 hairs that are intact with roots, would it be possible to have your laboratory keep one and share one with an independent laboratory?
Not at this time, because there's no guarantee that with 1 hair you can do PCR or any kind of, it's not necessarily conclusive. We may need both to do DNA analysis on. 1 is not always enough.
With the 4 hairs that do not have roots,
Yes.
would it be possible to share those for independent analysis?
Well, I believe rather than, we're going to, our approach to that normally would be, let me just put it in that form, would be that we analyze all 4, because we don't know whether they're similar at this point, came from the same individual, or could have come from the same individual. We would like to compare all 4 of those hairs to our exemplars, and then using via a master criminalist or something to that effect, allow your laboratory to have all 4 of those hairs or whatever, and they could be viewed by you, all 4 of them. You can't split the hairs. I think we went through this. I heard this on the news.
Yes, we did go through that, but let me just ask you, hairs aren't consumed in the analysis?
No, they're not in microscopic analysis.
So as far as that goes, that once you did whatever you were going to do to the hairs, the ones that without the roots, they could go to the defense and they could do whatever they wanted to with the hairs, presuming that they weren't destroyed somehow in their
Right.
analysis.
That's correct, Your Honor.
The ones with the roots are destroyed in analysis?
Just the portion that's consumed in the PCR analysis, the rest of it remains.
But the root portion would be
The
destroyed?
root portion is consumed, that's correct.
With regard to item 37, would you be kind enough to tell us the type of hairs that were recovered from that item, please?
37. That must be the other report that you still have.
So let me give
Or
you
do
all
I
the-
have it?
Let me give you all.
I have 58. Okay, thank you. Well, I have some notes on that. Apparently that must be one of the reports. I thought that was in your package that I gave you yesterday. Item number 37? Oh, that's the one that's not completed. Okay, that analysis is not completed at this time. We're still working on that.
So you cannot tell us how many hairs
No, I
that were
cannot.
there or what type of hairs
No.
they were?
No, that's still being worked on.
Do you know when you'll have that result?
Hopefully by Monday.
And regarding item number 38,
Item number 38, so that one's completed. Item number 113 are hairs, fibers, et cetera, and debris removed from item number 38. And the blue knit cap. Item 38 is the blue knit cap.
Thank you.
I'll just get summarized down to the important part here. There were 34 human hairs. 32 are consistent with head hair and 2 are consistent with body hair. Among the 32 head hairs, 25 are dark reddish brown to black in color, ranging in length from 0.7 to 3.5 centimeters and exhibiting predominantly negroid characteristics. Additionally, 4 of these 25 hairs have intact roots, while the remaining 21 do not. And these came from both the interior and exterior surfaces of the knit cap.
of the 4, I'm sorry, complete your answer, I'm sorry.
Okay, thank you. From the remaining 7 head hairs, 5 are blonde in color, ranging in length from 3.0 to 8.5. Okay, I'm sorry. I know that, but I'm reading. From the remaining 7 head hairs, 5 are blonde in color and range in length from 3.0 to 8.5 centimeters and exhibit predominantly Caucasian characteristics and exhibit indications of chemical treatment, i.e. bleaching. These hairs were all located on the exterior surface of the cap. The remaining 2 head hairs, also located on the exterior surface of item 38, are brown and reddish brown in color, 1.0 and 0.9 centimeters in length, respectively, and exhibit predominantly Caucasian characteristics. None of the above described 7 hairs have intact roots, and then there's several animal hairs and fibers which we have not characterized at this time.
Was there any blood found on item number 38?
Not on 38 per se at this time. We removed the hairs and fibers and have not done a complete blood search for it, but I believe it was laying near blood at the crime scene, and so it wouldn't surprise me if it's contaminated with blood.
Of the 4 hairs that were inside that appear to be Afro-American hair that have roots,
They have Negroid characteristics. They're not necessarily Afro-American hair. Okay, that's a characteristic, and he used terminology used in hair only, and I'm afraid they've never changed it, so we have to stick with that.
of those 4 hairs, are any of those available to an independent examiner?
Again, not at this time. We'd like to, but the ones with roots, I'm
Yes.
sorry, ones with roots, again, until the DNA is done, I prefer not to. We don't know. We don't know the strength. We don't know how old the hairs are, so we don't know how strong the DNA might be in the root. Again, at this time, I wouldn't want to give them up until our testing is done.
Where will that testing take place?
I believe we haven't totally decided where we're going to do it yet, but it probably will be done by an independent lab.
Your Honor, may I retrieve the documents that were given to me?
Certainly.
And I have no further questions. Thank you.
All right.
Sure. I think these are all yours. No, I think those are all yours, counsel. Yeah, they're all marked.
Ms. Clark, do you have some additional questions of the witness?
I do, very briefly. Ms. Kessler, with respect to the knit cap, item number 38, you indicate that on the interior of the cap was located 34 human hairs?
Now, the 34 hairs, as she stated here, that were from the interior and exterior of the cap.
That's total?
That's total.
Okay. Okay, 2 of those 34 hairs are consistent with body hair. Is that,
2 are consistent with body hair.
and were those 2 that were consistent with body hair found to be demonstrative of Negroid or Caucasian characteristics?
She didn't characterize them at this point, and she didn't also not, this is our hair analyst, we have not had time to look at them to see if we can tell that. Very often body hair is so fine and so small, it's impossible to determine origin.
And with respect to body hair, is that capable of being, do those 2 hairs have roots?
Apparently, it's not indicated here, and I don't have her notes. I just realized that she did not indicate roots or no roots.
Can that be determined?
Yes.
Then of the 32 head hairs, 25 were found to have Negroid characteristics,
Yes, that's correct, counsel.
and those came from the interior of the cap?
No, those are both from the interior and exterior.
And then the hairs that were determined to be primarily Caucasian, chemically treated blonde hairs, those were from the exterior?
Exterior.
Is it your plan at this time to subject all of the hairs to both PCR and microscopic analysis?
The only hairs that would be subjected to PCR analysis would be those with the roots. The rest would be microscopic examination.
Okay. And based on, in order to perform a microscopic analysis and comparison of hairs, how many head hairs do you need to retrieve from a suspect for the purpose of comparison?
I have a couple of references here, and the references all indicate 30 to 100 hairs. And one of my references is from a book, Forensic Science and Introduction to Criminalistics, by Peter DeForest, Robert Ganslin, and Henry C. Lee. And
I'm sorry, is that the same Henry Lee that we had testimony?
yes, it is.
concerning?
It's the only Henry Lee I know, and that was the one I'm assuming that was the one I was questioned about. On page 211
Of that book,
of that book, which I have
co-authored
extra,
by Henry Lee?
yes, of which I have extra copies here, if anybody wants to
May I approach them?
have
Yes.
one. On page 211, he refers to known samples of hair, and we're talking about microscopic examination only here, not DNA analysis. They're two entirely separate types of analysis needing separate samples. Known samples of hair should be given careful consideration. If questioned head hairs are to be submitted, then the known sample should contain representative samples from different parts of the scalp. Ordinarily, the hairs should not be cut. Vigorous combing or massaging of the scalp will usually yield 30 to 40, and he uses the term telogen hairs. That's basically adult hairs or fully grown hairs. If the questioned sample is thought to contain anagen hairs, which are pre-adult hairs, if you will, then so must the known sample, and these must be plucked. It is advantageous to have both plucked and combed hairs in the known sample in any case, and they should be packaged and labeled separately. And then I have another quote from the FBI from the symposium held on Proceedings of the International Symposium on Forensic Hair Comparisons. Again, I have copies for anyone that wishes to read them.
Is this the one that you furnished copies of to everyone?
Yes, that's the correct one.
All right.
May I refer you to, Ms. Kessler, may I refer you to page 11 of that document that has been furnished to court and counsel, which you furnished to me this morning, page 11,
Right,
the
that's
second
correct.
paragraph.
It is recommended that a known head hair sample consist of at least 20 hairs from each of 5 different areas of the scalp, and then refers to center, front, back, and both sides, and that these hairs be obtained by both pulling and combing. And then it goes on to talk about a little bit of procedure in doing that collection, and then it goes on to talking about how we select that, or what the routine procedure for selecting a random sample of those 100 hairs is. And that's where we have come up over the years from different sources for wanting between 30 to 100 head hairs for microscopic comparison for the exemplar.
Now, this article that you're quoting from that you just quoted from was put out by the Federal Bureau of Investigation.
That's correct.
It's dated 1985.
That's correct.
To the best of your knowledge, has the practice changed any among criminalists concerning the size of sample required for an effective microscopic analysis of hairs?
No, it has not.
And the book you quoted from, co-authored by Henry C. Lee, the portion that you just read to us would seem to indicate also that
I haven't heard the end of the question yet, so I can't quite rule.
reading the article that you've read to us, the portion of the article you've read to us from the book co-authored by Henry Lee, what do you deduce concerning his practice or advised practice in terms of the size of sample required to do an effective microscopic analysis of hairs?
Well, it appears to purport that the authors of this book indicate that a minimum of 30 to 40 hairs is necessary before you have an adequate sample.
Your Honor, I'm going to ask that the pages that have been Xeroxed by the witness be copied for both counsel and one for the court. I'd like to mark it or also admit this for the court's consideration in addition to the article that I've furnished the court with this morning.
All right, did you want to then mark those as actual exhibits with regard to the motion?
Yes, Your Honor.
And so we'll denote Proceedings of the International Symposium on Forensic Hair Comparisons article as People's Exhibit Number 1 for purposes of this motion only.
Thank you, Your Honor.
And would you describe the title of the other document, please?
Yes, Your Honor. It's entitled Forensic Science, an Introduction to Criminalistics, authored by Peter DeForest, R.E. Gainslen, that's Gaensslen, and Henry C. Lee.
And you wanted to note that as People's 2 for this
Yes, Your
motion?
Honor. Thank you.
All right. Do you have additional questions of the witness at this time?
Just a couple more, Your Honor. Thank
All
you.
right.
With respect to the information that you've given us concerning DNA analysis and the quantities of evidence required to perform those tests, where did you get that information?
The analysis, the amount of sample needed for DNA analysis has been given to us over the years by different entities and experts in the field, including the FBI, Cellmark, private laboratory Cellmark Diagnostics. Obviously, before we sent something to them, we needed to know what they purported to be the minimum sample that was required. It began, and I can indicate too, it began when we first started that a quarter-size sample of blood was necessary to do RFLP analysis, and they've progressed to where it's down to about what they refer to as a nickel size, which equates to one of our 1 centimeter square swatches soaked heavily with blood.
So do you undertake to conduct that evaluation with respect to blood evidence on a routine basis, and that evaluation being whether or not an evidence sample of blood is sufficient in quantity or quality for DNA testing?
Yes, we do. We have sent out over 100 cases for RFLP, all of which have been evaluated in the same manner that we've discussed here today, and those contained in excess of 400 items, which we've evaluated for RFLP or PCR or other types of analysis. And it's basically done on the basis that we discussed here today.
And when you say RFLP and PCR, you're referring to tests for DNA?
Yes, 2 different types of testing for DNA. That's correct.
So the evaluation process to determine how much, whether you have a sufficient sample for further testing is something that is done by you on a routine basis?
Yes.
And have you previously been consulted before as to whether there is sufficient evidence, blood, to allow for a split?
In other cases, yes.
And is that also done by you on a routine basis?
Yes, in last couple of recent years, I've turned that over to other people, but in the beginning, when we first began sending out DNA, I strictly did the evaluation myself.
I have nothing further.
Mr. Shapiro,
Yes.
anything further?
Your Honor, may I direct the court's and counsel's attention to our discovery motion item 29C, which we had filed last week regarding expert witnesses. Any and all writings or publications used in any way by the experts in forming opinions or obtaining a basis for forming an opinion, including teaching manuals, journals, treatises, textbooks, bulletins, and other records of classes in the expert's field of expertise or otherwise. Again, we've been repeatedly assured every time an issue comes up that all items of discovery will be complied with. Clearly, this has not been complied with.
Your Honor, it has. I turned over everything as soon as I received it. This morning, I received the item now marked as People's 1, and as counsel was able to see, the witness brought Peoples number 2 with her, and I didn't have any knowledge of it until the witness brought it in. And if counsel would like to question the witness as to how she came about obtaining Peoples 2 and whether I've ever seen it before she brought it out on the witness stand today, I'd welcome him to do so.
Mr. Shapiro, it strikes me that this motion with regard to the hairs was one that sort of came up rather suddenly based on your filing an order for my signature yesterday, I believe, limiting the hair sample to 1 hair, and that's how we got on this whole issue. And if you feel that you haven't had sufficient time to meet these manuals, then I'm willing to give you some additional time to deal with that. But I don't see that there's been any bad faith exercise on the part of the people at this point in time, in light of the short notice that we're dealing with here in this instance.
Thank you, Your Honor. We're prepared to proceed.
Thank you.
You're welcome. With regard to the book that you have relied on, have you read that book in its entirety?
No, I have not.
What portions of the book have you read?
Oh, over the years, I've read different portions. It's basically a reference book. I sort of collect books on forensic evidence, and especially by people I know, and I know all the authors of this book personally. So I have, read different parts here and there. I haven't read the whole thing. It's repetitive of many things. There's only small sections on hair and blood. There's other sections on, this is entirely forensic science. It's an introduction to criminalistics.
Regarding the section on hair that you have relied on in forming your opinion, do the authors of that book say how many hairs should be plucked for comparison for DNA analysis?
I don't recall, because this was written in 1983. And so for DNA, again, DNA, it takes a minimum, well, first of all, we're not going to do DNA on any of the hair we're asking for. We're only asking for the hair for microscopic comparison purposes.
So then you don't need any roots?
Yes, we need roots for microscopic comparison purposes. It's not a valid sample to be only looking at the shaft and not the entire hair.
My question now is, in reading the book that you've relied on in making your opinion, does it say how many hair samples of roots should be obtained?
Well, yes, I believe it did.
Objection vague. For what purpose? Microscopic analysis? What is counsel referring to?
I believe it.
Mr. Shapiro, are you referring now just to microscopic
Yes, Your
analysis? Thank you.
On page 211, I believe I referred to it before, it says, ordinarily the hairs should not be cut, which indicates plucking right off. They suggest plucking them all. That's the inference I read here.
Is that what it says? Well, would you read it?
It says, known samples, these are the known samples, should be given careful consideration. If questioned hairs are to be submitted, and that's our evidence hairs, then the known sample, that's what we're asking for, should contain representative samples from different parts of the scalp. Ordinarily, the hairs should not be cut. Vigorous combing or massaging of the scalp will usually yield 30 to 40 telogen hairs, or essentially adult hairs or viable hairs. If the questioned sample is thought to contain anagen hairs, which is underdeveloped hairs, then so must the known sample, and these must be plucked, because you cannot shake those out.
Does it say how many should be plucked?
It says ordinarily the hairs should not be cut. That's all 30 or 40 of them. And it says here that if you vigorously comb or massage the head, that you should be able to yield 30 or 40 hairs with roots. That's what they're inferring.
So what you are relying upon then is that a vigorous massaging of Mr. Simpson's head along with combing should give you sufficient sample.
That's what that one reference refers to. The
Okay.
reference of preference. I brought that specifically because of your reference to Dr. Lee this morning. And that's an older reference than the FBI symposium reference, which indicates that on page 11, that these hairs can be obtained by both pulling and combing, and they don't give a number. And no, we don't need a lot of roots,
Thank you.
but we
Nothing
need
further.
more than one.
Thank you. Nothing further.
Ms. Clark, do you have any further questions?
Any further?
I have just a couple of questions.
Sure.
Do you know approximately how many hairs a typical human head, male human head, contains?
No, I do not.
You have no idea at all?
No, it varies. It varies. I mean, just in looking around the room, it varies totally. I didn't mean that to be funny. It varies greatly.
Is there like a minimum typical number of human hairs?
No.
All right. In the course of an average day, is there some number of hairs that one loses just through the normal course of the day? Combing your hair and
Again, there's a random average of what you shed on a daily basis, but you tend to shed dead hairs which don't necessarily contain roots.
so when we're talking about 100 hairs, which is the most that your periodical indicates, and is that like a lot of hairs compared to the total number of hairs on a human head?
No, it is not. Not on someone with a full head of hair. I would say if someone is, and I don't want to point anyone out in the room, but I would say if someone is balding to an excessive degree, I guess 100 hairs would be a lot. And then you don't have all 5 areas to pluck from either, so you're only going to pluck from the areas available. So, you know, we're flexible here. That's why we say 30 to 100. We're not saying we have to have 100 hairs.
Okay. Are there any further questions based upon the court's questions?
Thank you, Your Honor.
Ms. Kessler, thank you very much. You may
Thank
stay.
you, Your Honor.
Ms. Clark, do you intend to present any other evidence with regard to this issue?
Not at this time, Your Honor.
Mr. Shapiro, do you intend to present any evidence on this issue at this time?
No, Your Honor, thank you.
All right. Does either side wish to be heard?
Yes, sir. Regarding the issue of blood samples, I think clearly with the number of samples that have been taken and the tests that have been done, to allow the Los Angeles Police Department crime lab to consume all of the samples deprives Mr. Simpson of his right to an independent analysis of the samples, and therefore will prevent him from ever coming forward to show that errors have been made in the analysis.
Ms. Clark?
I think that we have repetitively covered that ground. If what counsel is attempting to assure himself of is that there are no errors in the methods employed in the analysis, I have invited him and a team of experts to examine and observe every step of the procedure of testing as to every single item. I repeat that invitation again. I can only reiterate, Your Honor, that the investigation has to be governed by the appropriate scientific procedures as determined by the experts, and that the prosecution must be permitted to investigate its own case. To do otherwise would permit counsel to come forward, limit the number of tests that we conduct on a piece of evidence, and then argue to the court that the results of testing are unreliable because they were incomplete. Obviously, that's a catch-22 situation that the people should never be placed in. We want to thoroughly investigate this case and obtain every result possible to gain maximum confidence in the results. Any exclusion that is obtained by the result of any test may very well indicate that the source of the item in question is not the source that was anticipated, either be it victim or witness or defendant. Likewise, any inclusion would tend to corroborate the inclusions indicated by prior tests. So the complete testing of every item of evidence is clearly a very necessary and important thing. Therefore, people simply indicate that they are we are desirous of pursuing every test possible, and we invite counsel and all team of experts he wants to have present to please come and observe every process, test every buffer and every solution to make sure that nothing is contaminated, and that way we will preserve every right to which he's entitled.
All right, the court is prepared to make its ruling at this time. And that is this. What Ms. Clark has characterized as an invitation to the defense to be present at these various testing of these various samples about which we've heard testimony today is going to be more than an invitation. It's going to be subject to a court order that, in fact, the defense be present for the testing that's performed on any of these items, particularly in light of the fact that the only testimony that was presented today is that Ms. Kessler, who is the expert in this area who testified, does not know whether in fact any of the tests that are going to be performed will in fact consume the entire sample. In light of that fact that we do not know whether there'll be a sample remaining, in order to safeguard Mr. Simpson's rights in this matter, the court does order that the defense be entitled to be present as indicated, and not just by mere invitation, but as a requirement in this case. With regard to the hairs and the number of hairs, the court will order that the prosecution be entitled to obtain at least 40, but no more than 100 hairs from the various areas, the 5 areas as denoted in the scalp of Mr. Simpson. That should accommodate a sufficient sample of hair to perform microscopic analysis or any other analysis that the people have indicated that they may do, and sufficient sample for the defense also to perform their tests after the prosecution is finished performing whatever tests they need as well. If that at some point in time is insufficient, then the matter can be revisited at some future date. But I think that really should accommodate the needs of everyone, and hopefully we can put this issue to rest at this point. Now, with those matters taken care of, we can move to the substance of the hearing today, which is for the purpose of conducting the preliminary hearing in this case. And although we did have a brief conference in chambers with the reporter, I just want to reiterate on the record that both sides are ready to proceed to preliminary hearing. Is that right, Mr. Shapiro?
Yes, it is.
Ms. Clark?
That is, Your Honor.
All right. The court is in receipt of a notice of motion and motion to suppress and return evidence, to quash and traverse search warrant, and a memorandum of points and authorities and declaration of Gerald Ullman in support. That motion was filed yesterday afternoon, almost 5 o'clock. Now, it would be the court's proposal that we handle that motion, and at the time that we commence that motion, we are in fact commencing the preliminary hearing in this case, but that we handle the motion first before we get to any other kind of testimony or other issues with regard to the preliminary hearing. Is there any objection to handling the motion first?
If I may be heard, Your Honor.
Yes.
Thank you. The people were served this motion at 10 minutes to 5 last night. We had no prior notice of any intention of the defense to file such a motion. In light of that fact, we were prepared to proceed with civilian witnesses in this preliminary hearing, as I informed defense counsel pursuant to his phone call to me last night. In view of the fact that those witnesses were already prepared and subpoenaed to be in court, we were unable to contact them and rescind their subpoena in time, and they will be substantially inconvenienced at this point if we are to proceed with the motion in lieu of their testimony. What I'm asking of the court, if it is acceptable, Your Honor, is to present the testimony of these civilian witnesses and proceed with the motion on Tuesday, when the civilian witnesses will have been all contacted and told not to attend court, so that we can handle the motion instead.
All right. I personally have no problem with that. I assume that the testimony of civilian witnesses is not going to specifically relate to the issues or the evidence that's involved in this motion to suppress. Is that correct?
That is correct.
All right. Mr. Ullman?
With respect to the filing of the motion, Your Honor, much of the factual basis of the motion was based on testimony that was presented in the grand jury that the defense first became aware of on Monday or Tuesday of this week when we came to the grand jury transcripts. And the motion was filed just as soon as it was completed. We have no objection to proceeding with witnesses who will not present any testimony affected by the motion to suppress. But before any testimony is presented relating to evidence obtained at the premises of Mr. Simpson, we would like the motion to be read.
All right, I think that's an agreeable way to proceed in this case. And so we will defer then any further evidence with regard to the motion until Tuesday. You have sufficient civilian witnesses, you feel, to fill the remainder of today and tomorrow as well?
I believe I do, Your Honor. It's hard to predict the length of cross-examination, but I think that that will be the case.
All right. Do you have a witness available at this time?
Your Honor, I will be presenting the first two civilian witnesses on behalf of the people. It is my understanding that those witnesses are sequestered per the court's suggestion
Yes.
in an office upstairs. If I need granted leave to contact someone upstairs and see if I can have at least the first of those witnesses brought to this court.
All right, let me just ask a question. And I know that we got off to a late start because of things that were out of the control of any of us. If we were to take the 15-minute recess, which is a little bit earlier than I anticipated at this point, until 3 o'clock, which is actually a little bit more than 15 minutes, and then at 3 o'clock we began the testimony and went straight until 4:30, that would give you time to get your witness down here without any disruption at this point. Because otherwise the witness is probably going to take, 5 minutes or so to come from the 18th floor to get down here.
That's what I would expect.
And then we'd end up taking a break shortly after we began. So I think that's what we'll do. We'll take the afternoon recess at this point in time, begin promptly at 3 o'clock. Please have your witness here so that we can begin the testimony at that time.
Yes, I do.
State and spell your name for the record.
My name is Alan Wattenberg, that's A-L-L-E-N, last name Wattenberg, W-A-T-T-E-N-B-E-R-G.
You may inquire.
Thank you very much, Your Honor. Mr. Wattenberg, you are the co-owner of a business located here in the city of Los Angeles, are you not?
That's correct.
And what is the name of your business, sir?
The name of our business is Ross Cutlery.
And what type of business is Ross Cutlery?
Ross Cutlery is a retail cutlery store and sharpening service.
And Mr. Wattenberg, would you tell us where your business is located, please?
Our business is located at 3rd and Broadway at 310 South Broadway in the old Bradbury building.
And sir, how long has your business been located in the old Bradbury building?
My brother and I have had the business since 1965, and prior to that, another gentleman owned the business for about 40 years, and his name was Mr. Ross.
And during that period of time, has Ross Cutlery been located at one location or another within the old Bradbury building?
It's been located in 3 different locations within the building.
Now, Mr. Wattenberg, you are co-owner of Ross Cutlery, is that correct?
That is correct.
And with whom do you co-own Ross Cutlery?
I co-own Ross Cutlery with my brother Richard Wattenberg.
And sir, at this time, how many employees do you have?
We have, counting my brother and myself, there's 7 of us.
And sir, as of this time, is one of the employees who works for you named Jose Camacho?
Yes, there is.
And about how long has Mr. Camacho worked for you, Mr. Wattenberg?
Mr. Camacho has worked for me approximately 20 years.
And what is his job title?
He's in sales.
Mr. Wattenberg, I would like to direct your attention to the date of Tuesday, May the 3rd, 1994. Were you working at your business on that date?
Yes, I was.
And was Mr. Camacho, the employee to whom you have just referred, was he working that day as well?
Yes, he was.
Mr. Wattenberg, do you recall approximately what time you arrived at Ross Cutlery that day?
That day, I more than likely came in somewhere between 7 and 7:30.
And sir, are you the one who opens the business?
Generally, I am, yes.
And Mr. Wattenberg, on that date of May the 3rd, 1994, were you working during the afternoon hours?
Yes, I was.
And was Mr. Camacho working that afternoon as well?
Yes, sir, he was.
On that particular afternoon, Mr. Wattenberg, did you observe any unusual activity occurring outside of your business that afternoon?
Yes, sir, I did.
And would you please tell us what you observed?
This particular day, there was a film company there doing a pilot for a TV series, I believe.
And what types of things did you see that evidenced such filming or such a project underway?
There was a rather large film crew there with cameras, lights, and all the different items that go along with filming.
And specifically in relation to your storefront, where was this filming occurring?
Directly in front of our store.
And did you, during the course of that afternoon, happen to observe some of the filming as it was occurring?
Yes, I did.
And during the course of your observations of that filming, did you recognize anyone on the set?
Yes, sir, I did.
And who was that you observed, sir?
Mr. O.J. Simpson.
You see Mr. O.J. Simpson present in court today.
Yes, sir, I do.
Would you point him out for us, please?
The gentleman over there.
We'll stipulate he is a
Thank you.
Okay. Thank you, counsel. Mr. Wattenberg, during the course of that afternoon, did the defendant ever come into your store, Ross Cutlery?
Yes, he did.
And how many times do you recall him coming into your store that afternoon?
I believe I saw him there once, possibly twice myself.
Now, with regard to the first time, to your best recollection, did you pay close attention to the defendant as he came into the store?
Not really. We just let him browse around. We didn't bother him, or I should say I didn't bother him.
Was your attention drawn to other activities at the time?
At the other time, I was busy doing several different things in the store that I normally do.
I see. Now, were you present in the store that afternoon when Mr. Simpson, the defendant, came in a second time?
Yes, I was.
Okay. And would you tell us what occurred when you observed the defendant come in the store the second time?
I believe that he came in and looking into our store from the outside, he was looking at items on the left-hand side of our store, which would be the north side of our store. And I think Mr. Jose Camacho showed him several different items that he had an interest in, and he spent some time with him, talking with him and stuff.
And Mr. Wattenberg, where were you when you observed the defendant to come into the store the second time?
To my best of knowledge, I was at the front portion of the store on the other side.
Would this be on the south side of the building, or your store rather?
On the south side of the building, yes, sir.
At any point in time during the second time that the defendant came into your store, did he ever come over to your location on the south side of the store?
Yes, sir, he did.
And tell us what happened when the defendant came over either to or near your position, sir.
I believe, if memory serves me right, I spoke with him briefly, and he pointed out a couple of items on the back shelf of the display where I was standing, and I showed him an item.
And Mr. Wattenberg, when you refer to items, what do you mean, sir?
He had an interest in some knives that we sell.
What type of knives did the defendant express an interest in?
The item that I recall was a large lock blade knife.
And could you describe that particular type of knife a little further for us, sir?
Sure. This particular knife is about 15 inches in length when it's opened. It has a locking device on it that holds the blade in a fixed position. When you release the lock and fold the blade closed, I believe it's about maybe 8.5 inches in length. It has a stag handle on it with a shiny stainless steel blade. The blade has some engraving on it, and basically the ends, the hilt is brass, and there's a little guard toward the front portion of it that's also brass.
And Mr. Wattenberg, when you refer to a stag handle, would you explain what you mean, sir?
Stag handle is the antlers off of deer, and they utilize this quite a bit on some of the nicer, what they call collectible knives, because it makes an attractive handle.
Now, at the time the defendant was expressing interest in this particular knife, were you standing behind a counter of some sort?
Yes, sir. I was standing behind the display counter.
Is that a glass-topped display counter?
Yes, it is.
And where was this particular knife in which the defendant had expressed interest?
Directly behind me.
Was it on a wall?
It's on a wall, yes, sir.
Did you remove that knife from the wall in order to show it to the defendant?
Yes, sir, I did.
And would you please describe what happened, sir?
About the time when I took the knife off the wall to show it to the defendant, Mr. Camacho, which had been waiting on him previously, entered the picture, and I had some things that I needed to do in the back, so Mr. Camacho continued the sale.
Now, with regard to the manner in which this particular knife was it displayed with the blade open or closed within the handle?
And to my best knowledge, it was open.
And when you displayed the knife, that is, took it from the wall and displayed it for the defendant, was the blade open or within the handle?
As far as I can recall, it was, yes, sir.
Now, Mr. Wattenberg, at the time, and as of this particular date, did you have more than one size of this particular type of knife within your store?
At the particular time, I think we had two knives similar to this on display, one short one and one long one.
And how much shorter was the shorter one than the longer one you've described?
Possibly a couple of inches. I don't know the exact dimension of it.
Was there a price difference between the two?
There's a slight price difference, yes, maybe $10 or $15 difference in price.
Do you recall the price of the larger knife which you showed to the defendant?
I believe the larger knife was $74.98.
Now, do you recall showing the smaller version of this larger knife to the defendant that afternoon?
I really don't recall whether I did or not.
Is it possible that you did?
It is possible that I did. I was very busy that day and might not remember it.
And you recall, sir, however, showing the larger knife to the defendant, is that correct?
That is correct.
Are you certain of that?
Yes, I am.
How certain are you of that?
Very sure.
Now, did you continue to have did you have any sort of conversation with the defendant as you were showing him this knife?
I really can't recall whether I did or not.
Did the defendant express an interest in purchasing this particular knife?
At the present time when I was there showing it to him, he just wanted to see the knife, which I took off the back display, and I don't know if I handed it to him or put it on the counter, but I did, show it to him.
At some point in time, Mr. Wattenberg, did Mr. Camacho come over to assist you with the defendant?
Yes, he did.
Okay, tell us what happened then, sir.
After then, I believe that I excused myself. I had some things that I needed to do in the back, some paperwork, and I left and returned to the back of the store where we have like a little office area.
Shortly thereafter, did you see Mr. Camacho again?
Yes, a little bit after that, Mr. Camacho came to the back where I was, and he handed me the knife and told me that the customer wished to have it sharpened. I took it in the back where we do our sharpening, and I sharpened the knife, and then I returned to the front with it, and I put it on the counter.
Now, sir, when you're referring to the customer, are you referring to the defendant?
Yes, sir, I am.
And with regard to the knife that was brought back to you, was this the same knife that you had brought off the display and presented to the defendant or showed to the defendant?
Yes, sir, it was.
This was the larger 15-inch overall dimensioned knife, is that correct?
Yes, sir, that's correct.
Now, Mr. Wattenberg, is there a difference between a single-edged knife and a double-edged knife?
Yes, sir, there is.
Would you explain the difference for us, please?
Sure, a single-edged knife is sharpened on one side only, and a double-edged knife is sharpened on both sides.
And what type of knife was this knife that you sharpened for the defendant that afternoon?
This knife was a single-edged knife sharp on one side only.
With regard to the other side of a single-edged knife, is the edge, as with regard to this particular knife, blunt, dull, sharpened? How would you characterize it?
On this particular knife, the reverse side is completely flat or blunt.
Now, with regard to the knife that you sharpened for Mr. Camacho, you were certain that this was the larger of the stiletto-type knives that you've described, is that correct?
Yes, sir, that's correct.
Now, what did you do, Mr. Wattenberg, after you sharpened the knife for Mr. Camacho?
After I sharpened the knife for Mr. Camacho, I put it on the counter, and continue to, doing what I was doing in the back. I believe I was doing some paperwork or possibly doing some ordering. I don't remember exactly, it's length of time ago, so I couldn't tell you exactly what I was doing, but some type of office work.
Did you ever see the defendant leave your store that afternoon?
No, I don't believe that I did. I was in the back working, and I don't believe that I saw him leave the store.
You had some awareness developed at some point that he had in fact left the store, is that correct?
Yes, sir.
Mr. Wattenberg, I would now like to direct your attention to Tuesday, June the 14th, 1994. Were you working at Ross Cutlery on that particular day?
I believe that I was. I'm not familiarized with that particular day. It was on a Tuesday, you said?
That's correct.
On a Tuesday, I definitely would have been there.
And do you recall a date when some detectives from the Los Angeles Police Department arrived at your store?
Yes, sir, I do.
And you were present when they arrived?
Yes, I was.
Were any other employees present besides yourself?
There were several other employees there.
Amongst them were your brother, Richard.
Yes, my brother Richard was there.
I suppose it would be unfair to characterize your brother Richard as an employee. He is in fact a co-owner.
Co-owner,
is he not?
correct.
But amongst the employees present was Mr. Camacho there.
Yes, sir, he was.
And did you speak with the detectives from the Los Angeles Police Department?
Yes, sir, I did speak with them.
Did your brother Richard speak with the detectives?
Yes, sir, he did.
And did Mr. Camacho speak with the detectives?
Yes, sir.
During the course of your conversation with the detectives from the Los Angeles Police Department, did you show them a knife?
Yes, sir, we did.
Were you asked by those detectives to show them a particular type of knife?
Yes, sir, we were.
And tell us what you did, sir.
I took them to the front area of my store where these particular knives were sold and proceeded to show them the knife.
And by the knife, what knife are you referring to, Mr. White?
They had an interest in the knife that we had previously sold to Mr. O.J. Simpson.
And did you show them an identical knife?
Yes, sir, I did.
And was that knife identical as far as you can determine to the knife that was sold to the defendant?
It was identical in size and type. Some of these knives will vary a little bit because the stag is a natural material, so it could be a little darker, a little lighter, but the overall size and function of the knife is the same.
Was the knife that you showed to the Los Angeles Police Department detectives identical in terms of price?
Yes, sir, it was.
Was it also priced at $74.98?
Yes, sir, that's correct.
Was that knife sold to the detectives from the Los Angeles Police Department?
Yes, sir, it was.
Your Honor, at this time I would like to mark an exhibit for identification. Would the court prefer that I mark it next in order as 3, or may I mark it as People's 1 for purposes of the prelim per se?
All right, we'll call it People's 1 for purposes of the preliminary hearing.
Thank you, Your Honor. And may I approach the witness?
Yes.
Your Honor, I have here a board upon which is contained 4 photographs depicting various aspects of a knife, which I would characterize as being a knife as described by Mr. Wattenberg in his testimony this afternoon. Each of the 4 photographs is designated by a letter A, B, C, and D. May this exhibit be marked as People's 1 for identification.
Yes.
Thank you very much, Your Honor. Mr. Wattenberg, I'm going to direct your attention to the exhibit which has now been marked as People's 1 for identification. Do you see that exhibit, sir?
Yes, sir, I do.
And specifically, do you see the photograph which has been designated as photograph A?
Yes, sir.
And would you describe for us, sir, what is depicted in photograph A?
In photograph A, there's a picture of the knife in its open position. This is a knife that we currently sell in our store.
And when you refer to the knife, again, do these photos depict in a true and accurate fashion the knife that was sold by your store to the detectives from the Los Angeles Police Department on or about June the 14th?
Yes, sir, this one appears to be the exact knife.
So with regard to photograph A, sir, does that photograph depict some of the characteristics of the knife purchased by the defendant on May the 3rd and that you have described in your testimony?
Yes, sir, that's correct.
Sir, I'd like to direct your attention to the photograph designated as photograph B. Do you see that photograph, sir?
Yes, sir.
With regard to that photograph, does that photograph depict the overall dimensions of the knife that was sold to the detectives from the Los Angeles Police Department and which was identical to the one sold to the defendant?
Would it be possible for me to take a closer look at it?
With the court's permission.
Of course, you can step down and take a look.
Yes, sir, that appears to be the knife. It's equal length to the one that Mr. Simpson purchased and also the detectives from the police department purchased.
And in terms of dimensions, Mr. Wattenberg, what is the overall length for that knife?
The overall length is approximately 15 inches.
And sir, when we refer to overall knife, we are referring to the knife in a locked, open position, are we not?
That is correct.
Directing your attention, sir, to photograph C, the photograph designated with a C. Do you see that, sir?
Yes, sir, I do.
And Mr. Wattenberg, what does that photograph depict?
That photograph there is showing the length of the blade.
And what is the length of the blade as depicted in that photograph?
The length of the blade in the photo is approximately 6 inches.
Mr. Wattenberg, earlier in your testimony this afternoon, you described some inscription on the blade that was sold to the defendant. Is that correct?
That is correct.
And do you see either similar or identical inscription upon the blade depicted in photograph C?
The engraving on the blade is identical.
And what does the engraving, what is the engraving? What is engraved on that blade?
On the blade, it's engraved stiletto, and then it says Germany underneath it.
Now, Mr. Wattenberg, I'd like to direct your attention to the photograph designated with a D. Do you see that, sir?
Yes, sir, I do.
And what does that photograph depict?
That photograph shows the knife in a closed position.
And can you give us the approximate dimensions of the knife in a closed position?
In a closed position, it's approximately, I believe, 8 inches.
Oh, Mr. Wattenberg, in your testimony today, you've described the knife that was sold to the defendant as a locking blade knife. Is that correct?
That is correct.
Would you tell us what that means, sir?
Okay, a locking blade knife is a knife that has a mechanism in it that when the blade is swung to an open position, it locks it into that open position so it won't easily close when it's being used.
And by what process, sir, does one close such a knife if one wanted to?
On this particular knife, there's a lever at the rear portion of the knife that you push down and then fold the blade closed.
And except for depressing that lever, would the knife remain locked in an open blade position if positioned that way?
In most general use, it would, yes, sir.
Now, Mr. Wattenberg, you are aware, are you not, that your employee, Mr. Jose Camacho, testified before the Los Angeles County Grand Jury last week, are you not?
Yes, sir, I am.
And after Mr. Camacho testified, did you become aware that he had been approached by various individuals from the media who were trying to get Mr. Camacho to talk to the media?
Okay, let me clarify this because I was on a vacation and I was gone the week that this all transpired. I learned of this after returning from vacation, so I have to testify in that regards that I wasn't there when the news media deluged our store, but I learned of it afterward.
And is it your understanding, sir, that the news media deluged your store only after Mr. Camacho testified before the grand jury?
To my knowledge, that's correct, yes.
And Mr. Wattenberg, after you returned from your trip, did you become aware that Mr. Camacho, as well as your brother, had signed some sort of agreement with someone?
Yes, sir, I did.
And what was your awareness?
They had signed an agreement with the Enquirer magazine, National Enquirer.
And when was it that you became aware of this agreement?
I was made aware of this when I returned on Saturday. Let's see, I don't know the date on Saturday, was last Saturday. Approximately maybe 8 o'clock when I got home, I called my brother, and my brother told me what had transpired during the week when I was gone.
Mr. Wattenberg, did you sign an agreement with the National Enquirer?
No, sir, I did not.
However, sir, do you expect to profit in some manner from your brother and your employee, Mr. Camacho, having signed such an agreement?
Yes, sir, I do.
And would you explain to us, please, how you expect to profit?
My brother and I, being equal partners in the business, are going to divide this money up 3 ways. Mr. Camacho will receive 1/3, my brother 1/3, and myself 1/3.
And what sum of money are we talking about, Mr. Wattenberg?
The figure, I believe, is $12,500.
Have you been contacted personally by anyone from the National Enquirer?
Yes, sir, I have.
And would you describe the circumstances of that, please?
A gentleman named Mr. Alan Smith, which is the senior reporter for the West Coast, called me, I believe, on Saturday. Can I clarify one thing? Because I just realized that I made a mistake.
Be my guest, sir.
I returned on Friday evening, not on Saturday, from my trip from Germany. On Saturday morning, I got a call from Mr. Alan Smith that he wanted to purchase one of these knives to send it in to the Enquirer so they could use it for photo purposes. And I don't remember the exact time. Mr. Smith came in the store. We talked briefly. He purchased the knife. I called Federal Express, I believe, and they sent a courier to pick up the knife about an hour later, which we had ready for them.
Well, Mr. Wattenberg, to your knowledge, has your brother or Mr. Camacho received any money from the National Enquirer as of today's date?
No, sir, we have not.
Do you have some expectation of when you might receive some money from the National Enquirer?
My brother was instructed by the National Enquirer that after the story has run for a week, that we would be, given the payment.
And sir, when do you expect the story to run?
The story is due to be released Monday.
Now, have you described the extent of your contact, your personal contact with the National Enquirer?
Yes, sir, I have.
And sir, to date, you have not received any money from the National Enquirer, is that
No,
correct?
I have not, sir.
Mr. Wattenberg, if I may, with regard to the figure of $12,500 that you've indicated in your testimony this afternoon, is that figure or that sum to be divided equally amongst the 3 of you, that is yourself, your brother, and Mr. Camacho?
That is correct, sir.
And it is not the fact that you are to receive approximately $12,500, your brother receives $12,500, and Mr. Camacho receives $12,500.
No, it's a total of $12,500 complete, all 3 of us together.
Thank you, Mr. Wattenberg. No further questions.
Thank you. Mr. Shapiro?
Good afternoon, Mr. Wattenberg.
Good afternoon, sir.
You described this knife as a collectible.
Yes, sir.
What is a collectible?
A collectible is generally a finely crafted knife that collectors would be interested in.
Are there different categories of knives that you carry in your store?
Yes, sir, there are.
What are those categories?
We carry cook's knives, butcher knives, general purpose kitchen knives, pocket knives of every size and description that you could think of, hunting knives. You know, the list could go on and on. There's many, many different categories of knives.
How would you differentiate a hunting knife from a collectible knife?
A hunting knife could also be a collectible knife. It would depend on who made it and the quality involved.
What is the main purpose of a hunting knife?
The main purpose of a hunting knife is fishing and hunting,
And to use for what purpose?
generally for a cutting tool.
And are those usually single-edged or double-edged?
Most hunting knives are with a single edge.
And did Mr. Simpson at any time ask to see a hunting knife?
I believe that he did, yes, sir.
And you showed him numerous knives, did you not?
Myself personally, I did not.
Mr. Camacho, to your knowledge, did?
Yes, sir, he did.
Do you maintain books and records in the course of your business?
Yes, sir, we do.
And do you maintain an inventory of your business?
We carry not a complete inventory. We do an inventory like annually, you know, for the city requirement or whatever.
And do you keep a record of sales in the normal course of your business?
We generally ring up items on a cash register, and at the end of the day, we take a total. We keep a total of repairs, because repairs are non-taxable. At the end of the day, we fill out a daily cash sheet which indicates the total of sales and the total of repairs.
Does your receipt have does your cash register record the individual prices for items that are sold during a given day?
Generally not, sir.
Have you checked your receipts for this particular day?
Yes, I have.
And did they keep a list of the individual purchases?
No, this sale was just a cash sale, which was rung up on the cash register.
When a sale is made in the normal course of your business, is a receipt given?
There are times when a receipt is given if a customer requires it, or if it's something that's being like mailed that we need a record of, you know, for mailing purposes, or if an item is put on layaway, there are receipts made out. But if a sale is made, just a cash sale, it is rung up on the cash register.
Are duplicate receipts made?
No, sir, they're not.
Just one copy of one receipt,
Yes, sir.
and that goes to the customer?
That's correct, sir.
So what you are telling us is you have no records whatsoever to establish that this particular item for this particular price was sold on this particular day?
That would be correct, sir.
Regarding the exhibit that you've been shown and that was purchased by the Los Angeles Police Department about a week ago,
Yes, sir.
except for the handle, you would say the knife is the identical knife?
Yes, sir, that's correct.
And the handle will vary in design and color?
There could be slight differences in the color and texture of the bone.
Thank you. Nothing further.
Mr. Hodgman, anything further?
And Your Honor, I have no redirect.
All right. Thank you, Mr. Wattenberg.
Thank you.
Until you're officially excused from giving testimony in connection with this matter, I'm going to order you please not to discuss your testimony with anyone. Thank you.
Thank you.
Do you have another witness available at this time?
I do, Your Honor. Mr. Jose Camacho. Mr. Camacho, I understand, is sequestered in the hallway.
All right.
I guess that's not really sequestration.
Face the clerk. Raise your right hand, please, sir.
Do you solemnly swear the testimony you're about to give and the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God? Seated. State and spell your name for the record.
Jose Camacho is Jose Camacho is Camacho. Camacho.
Thank you. You may inquire.
Thank you very much, Your Honor. Mr. Camacho, you work at the cutlery store known as Ross Cutlery, located at 310 South Broadway in the city of Los Angeles, do you not?
Yes, sir.
And, sir, how long have you been working there?
I've been there for 22 years.
And what is your job there, Mr. Camacho?
I'm a salesman.
Mr. Camacho, I'd like to direct your attention to the individual I'm standing behind. Do you recognize this man, sir?
Yes, sir.
And who is this man?
So, Mr. O.J. Simpson.
Indicating the defendant, Your Honor.
Yes.
And, Mr. Camacho, have you ever seen the defendant in the cutlery store where you work?
Yes, sir, I did.
And do you recall about when that was, Mr. Camacho?
Oh, this is about 9 or 10 weeks ago, something like that.
Do you recall the exact date?
Be like close to May, on May. I can recall exactly the date.
Your best estimate is 9 to 10 weeks ago, is
Yes,
that
sir.
correct? Now, Mr. Camacho, on the date that you saw the defendant in the store where you work, is there anything unusual or extraordinary going on outside the store?
They were filming a movie there at front of the store.
And at any point in time during the course of that filming, did you go out and take a look and see what was going on?
Yeah, we got to the lobby, and we were watching all the actors there.
And at some point in time during the afternoon hours of the date of this filming, did you see the defendant come into the cutlery store?
Yes, he walked in to the store.
And tell us what happened after the defendant entered the store.
Well, when I saw him walking into the store, I just, I looked at him, and then I knew who he was. And then he asked to see the knives. So I showed him where the knives were.
Now, sir, at the time the defendant asked you to see some knives, do you recall where you were within the store? Meaning, were you near the north display counter or the south display counter in the store?
Well, when he walked into the store, I was at front, and then I walked through the back of the store where those knives were, and he asked me some prices for the knives, so I just gave him some prices.
So did you show the defendant, or excuse me, I'll withdraw that. Did the defendant express some interest in various knives?
He liked one special knife. It's a small knife. It's made by Case. And I showed it to him.
Tell us a little bit about the knife, the best you can recall.
It's a collectible item. It's a knife that is not made anymore. And it's a nice looking knife. And he, when I showed it to him, he said that he wanted to buy it. But at that time, he didn't have no money to purchase it. So he told me that he was going to come back and buy it. And then at that time, he got called, to go and film again. So he left.
And Mr. Camacho, sometime later that afternoon, did you see the defendant in the store again?
Yes, he came back about 45 minutes or an hour later.
And what happened when the defendant came back later that afternoon?
Oh, when I saw him walking in back to the store, so I knew what he wanted, so I walked through the back of the store, tried to show him the knife again. But then somehow he, I guess he liked another knife at the entrance.
So what happened, Mr. Camacho?
So I followed him where he was going through the front of the store. And then I showed him, or I didn't say I showed him. My boss was at front already.
And by your boss, to whom are you referring, Mr. Camacho?
Mr. Alan Wattenberg.
The witness that just testified before you?
Yes, sir.
And what happened there at the front of the store in the vicinity of Mr. Wattenberg?
When I got there, he was already showing a certain knife that he purchased.
What type of knife was Mr. Wattenberg showing to the defendant?
He showed in one of the. It's a German-made knife. It's also a collectible. It's made by a company. It's called Cuisine Grain. It's a knife that is about 15-inch over length.
You know, Mr. Camacho, directing your attention to the left side of the witness stand to 4 photographs that have been collectively marked as People's One. Do you see that exhibit, sir?
Yes, sir.
do those appear to be photographs of the type of knife that at one point that afternoon was sold to the defendant?
That's the item I sold them.
Or more accurately, an item like the one you sold them, is that correct to your knowledge?
Yes, the first I know that's the one, the item or like the one I sold to him.
Okay. Did Mr. Wattenberg continue to assist the defendant in the display of this particular knife, or did you have some role in the transaction?
Well, when I got close to them, another customer was waiting for me. So I went and waited on this other customer. When I finished waiting on this other customer, I went back to Mr. O.J. Simpson to finish the sale that I was doing.
Did Mr. Wattenberg
then,
remain, pardon me, did Mr. Wattenberg remain with you and the defendant while the sale was completed?
Yeah, Alan was with Mr. O.J. Simpson. And then when he said that he wanted the knife, he required the knife sharpened. So I gave the knife to Alan so he can sharpen it.
Mr. Camacho, I'd like to back up in terms of time just for a little bit here. When the defendant went over to the location where Mr. Wattenberg was, did you see him gesture or point to a particular type of knife?
Yeah, he just, I guess something attracted him about the knife. It's a nice looking knife. And he just, he liked it.
Well, at the time, sir, and Your Honor, I ask that that be stricken because that really calls for a conclusion on the part of the witness.
Well, can I have an answer read back, please?
Answer. Yeah, he just, I guess something attracted him about the knife. It's a nice looking knife, and he liked it.
The objection is sustained. The answer will be stricken.
Thank you. After the I guess portion, Your Honor?
Yes.
Thank you very much, Your Honor. Now, Mr. Camacho, at the time that the defendant appeared in your store, were there different sizes of the same type of knife as depicted in People's One?
Yes, there are two different sizes.
And was the other size knife larger or smaller than the one that was sold to the defendant?
It's a tiny bit smaller, probably an inch or 2 inches smaller than the large size.
And is the larger knife, at least at the time, was it priced differently than the larger knife?
Yes, it is.
Do you recall the price of the larger knife, that is the knife that was sold to the defendant that day of the filming?
The price on that knife I sold was $74.98 plus the tax.
And Mr. Camacho, at this time, do you recall how the smaller knife was priced?
I believe the smaller one is priced $59 or $64, something like that.
Now, during the course, well, I'll withdraw that. After Mr. Wattenberg went to the back area of the store, you assisted the defendant in the sale of this larger knife, is that correct?
Yes.
And did the defendant pay for the knife, or how did the defendant pay for the knife?
He paid me with a $100 bill.
A cash
In
transaction?
cash, yes.
And did you make change for the defendant?
Yes, I gave him the change.
As of today, do you have a general idea of the total cost of the knife, that is price plus tax?
The total price was $81.17.
Now, before you actually received the cash money from the defendant, did the defendant ask you to do anything with regard to the knife?
He wanted it sharpened.
And after the defendant asked you to have the knife sharpened, what did you do?
So I gave it to Alan, so he went back to the shop and resharpened it.
And what did you do after you took the knife to Alan for purposes of sharpening the knife? Did you go back to the defendant? Did you remain with Alan? What did you do, sir?
I finished, bringing up the sale, like give the change to Mr. O.J. And then I went back to the shop to get the knife and give it back to him.
At the time you sold the knife to the defendant, did you give him a receipt or a copy of the sales tape or anything like that?
Yeah, I gave him the receipt.
Was there a receipt that was made for the store that you recall? Or was it just the sales?
Just regular register sales.
And sir, it's your testimony then that after the $100 bill was presented by the defendant, after you made change, that you went back to where Mr. Wattenberg was and obtained the knife, is that correct?
Yes, sir.
To your knowledge, had the knife been sharpened?
It was sharpened.
And what did you do then with the knife after you retrieved it from the area where Mr. Wattenberg was?
I picked it up from the desk and then I just put him in a plastic bag and I handed it to Mr. O.J.
And after that, did the defendant leave the store?
Yes, sir. He got the knife and he just started walking out.
Mr. Camacho, about 2 weeks ago, were you interviewed by detectives from the Los Angeles Police Department?
Yes, sir, I was.
And where were you when you were interviewed by those detectives?
I was at the store.
At the time you were interviewed, was anyone else from the store interviewed by those same detectives?
Yes, Alan Wattenberg was there, my boss.
I'm sorry?
Alan Wattenberg.
And what about the other co-owner, Richard Wattenberg? Was he there, to your recollection?
Yeah, he was there too.
And did the detectives ask you some questions during the course of this interview?
Yes, I did.
And during the course of this interview, were you asked to show a particular type of knife to the detectives?
Yes, they asked me to show them a similar knife that I had sold to Mr. O.J. Simpson.
And was that done?
Yes, I did. I showed them the same knife that I had sold.
And, sir, with regard to the type of knife, was this the larger or the smaller of the two knives?
The larger size.
Was the knife that you showed to the detectives also priced at $74.98?
Yes, sir, the same price.
And did the detectives purchase that knife?
Yes, I did.
And with regard to the purchase price of the knife that you sold to the detectives, are you certain that it was $74.98?
I charged them the same price because they're all marked. It's the same.
Did the person who is in charge of the grand jury tell you the following? Mr. Camacho, you are admonished not to reveal to any other person, except as ordered by the court, what questions were asked of you and what responses were given. In addition, you are not to reveal any other matters concerning the nature or subject of the investigation which you learned during your appearance here, unless and until such time as a transcript of these proceedings is made public. I wish to advise you also that a violation of this order can be the basis of a contempt charge against you. Will you read that, sir?
Yes, he told us that also, but he said that was up to us if we want to talk, you know. We could if we want to.
Who said that to you? Mr. Kahn or Ms. Clark say that to you?
No.
Did one of the lawyers in this case say that to you?
No, sir.
Did one of the police officers in this case say that to you?
No, I don't see anybody.
Do you recall whether it was a man or woman who said that to you?
It's a lady.
What did she look like?
You got me all confused. Well, she's not here.
What did she look like?
It's I don't want to put her in trouble. It's Patty, I would say. She told us that we could talk to the press, you know, if we wanted to. That was it.
I'm sorry, I did not understand the response.
Did you say Patty?
Yes.
And who do you mean by Patty?
Well, that's her name.
Who does she work for, do you know?
She works here in the building.
Did she work for the district attorney?
Yes.
Yes?
Yes, she does.
Thank you, nothing further.
Mr. Hodgman?
Yes. Mr. Camacho, isn't it a fact, sir, that you were told by District Attorney's Office representatives not to speak to the press?
Oh, man. That's what I understand, you know, that we could talk, but if you want us, you know, if you wanted to say something.
Are you a little uncertain about this, Mr. Camacho?
Yes. Well, that's what I was told. What else can I say?
I'm sorry, you have to speak up. What did you just say, sir?
I was just told like this, you know, see, if we wanted to talk, you know, we can talk to the press.
And you're referring now to what Patty told you?
Yes.
And open the question.
Mr. Shapiro, anything further? All right, Mr. Camacho, I'm telling you, and I want this to be very clear, that until such time as you have officially been excused from this proceeding, you are not to speak to anyone concerning your testimony except for the lawyers in this case. Do you understand?
Yes, ma'am.
Thank you very much. You may step down. Is there another witness available at this time?
Yes, ma'am.
All right.
You will call Mr. John DeBello.
Face the clerk, please, and raise your right hand.
You solemnly swear the testimony you're about to give and cause your opinion before this court shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Seated. Stand and spell your name for the record.
My name is John DeBello, Johndee, capital BELLO.
You may inquire.
Thank you, Your Honor.
Of course. Ms. Clark.
Thank you. Mr. DeBello, can you please tell us what you do for a living?
I'm the restaurant manager of Mezzaluna Restaurant in Brentwood.
And where is it located?
It's at 11750 San Vicente Boulevard.
Can you tell us, sir, how close it is to the intersection of San Vicente and Bundy?
It's about a half a mile.
Now, what exactly are your duties there?
I'm the general manager of the restaurant. I do all the hiring, firing, and make sure that the food comes out good all the time, consistent. And I'm there from morning till night usually. And I get a day off during the week.
Maybe?
Maybe.
And when you say morning to night, sir, can you tell us what do you mean? Starting when, ending when?
I usually get there at around 10:30 in the morning, and if I'm doing a long day, it's around till 1, 2 in the morning the next day.
And how long have you been working there in that capacity, sir?
For the past year.
That would mean since June of '93?
That's correct.
I'm going to show you a photograph that I'd like to mark. I'll show it to counsel first. People's 2, Your Honor?
Yes.
And the second photograph, People's 3.
All right.
So showing you the photograph that has been marked People's 2 for identification. Can I ask you if you recognize the person depicted in that photograph?
That's Ronald Goldman.
For the record, this is a certified copy of the DMV license of Ronald Goldman. How do you know him, sir?
I hired him approximately about 4 months ago as a waiter,
And
full-time.
Full-time?
Yes,
And he worked there for the past 4 months steadily?
that's correct.
Showing you now People's 3 for identification, sir. Do you recognize the person depicted in that photograph?
Yes, I do. Nicole Brown.
For the record, this is also a certified copy of DMV for Nicole Brown. How did you know her?
She was eating in my restaurant that night of the murders.
Had you seen her before that night, sir?
Yes, I have, several times.
Would you call her a regular in that restaurant?
She frequented the restaurant quite often.
Directing your attention, sir, to the night of June the 12th, 1994. Did you work that night at the Mezzaluna restaurant?
Yes, I did.
What time did you get to work?
I got to work about 6:45 in the evening.
Did you see Ronald Goldman there when you arrived?
Yes, he was on duty that evening.
Now, do the waiters in your restaurant, sir, do they wear any kind of uniform?
Yes, they do.
And can you describe it for us, please?
The uniform for all my waiters is black pants, dress pants preferably, a white shirt, a tie, and a vest. It can be a vest of their choice, as long as it's tasteful.
And did Mr. Goldman wear that uniform on the night of June the 12th, 1994?
Yes, he did.
If you know, sir, did he live anywhere near the restaurant?
He lived a few blocks from the restaurant. Yes, he did.
Now,
Within
when you,
walking distance.
I'm sorry?
Within walking distance.
When you arrived at 6:45, did you happen to see Nicole Brown there?
Yes, I did.
Was she alone?
No, she was not.
Who was she with?
She was with a party of 10, and they made reservations that evening to dine.
And their party was already in progress, dining then at the time you arrived at 6:45?
They were, yes.
Can I ask you, were there children in that party, sir?
Yes, there were.
Now, regarding the layout of your restaurant, do the customers enter and exit through the front door?
Most of the time they do, yes.
Is there another exit besides the front door?
There is a exit that we use for our patio dining and also handicap.
And where is that located?
That is on the Gorham side of the restaurant, Gorham Street side.
So that's a side exit, sir?
Yes.
Now, the waiters and the employees, do they enter and exit through the front entrance?
It depends on which direction they're coming from. Mostly the Gorham entrance and exit they come through.
Meaning the side entrance?
Side entrance, yes.
Does your restaurant have a bar?
Yes, it does.
And where is that bar located?
It's on the west side of the restaurant, which would be the inside. The west side meaning the east side would be the side facing the street, and the west side would be the wall with the bar right there.
Where is that bar in relation, sir, to the side exit you've been referring to?
It's about 20 feet from the exit.
If you were to leave through that side exit, would you necessarily then have to pass by the bar?
All the time, yes.
Do you recall who was waiting on Nicole Brown's party that night, June the 12th, 1994?
One of our waitresses.
And were you present when Nicole and her party left?
Yes, I was.
What time was that approximately?
I would say about 8:30, 8:45, within that time frame.
Now, do the employees in your restaurant punch in and out on a time clock?
Every day.
And did Ronald Goldman punch out that night?
Yes, he did.
What time?
9:33, and I initialed his time card.
If you know, sir, did you observe that he left immediately after he clocked out?
No, he did not.
What did he do, if you know?
Well, he loosened his tie. I think he took off his vest and he had a drink. I think it was a Pellegrino or something. Pellegrino. It's a mineral water. Sorry.
And did you have a conversation with him?
Yes, I did.
Did anyone else have a conversation with him after you?
A couple of my waiters, bartender,
And who was the bartender that night?
Karen Crawford.
Are you familiar with someone by the name of Stuart Tanner?
Yes, I am.
Was he in the restaurant that night?
No, he was not.
Who was in the restaurant that night?
Well, there were 3 waiters, the busboys, myself. Oh yeah, I'm sorry. Stuart was tending bar that evening. I'm sorry. I got this mixed up. Excuse me.
That's fine, sir.
All right.
Are you certain Stuart Tanner was tending bar that night?
Right. Karen was is my assistant on my Sunday evenings, and that's why I get that confused once in a while. So she was doing the front door, and Stuart was tending bar.
So are Sunday nights something different than during the rest of the week?
It's usually one night I get to rest a little bit. So,
Why is that? Does Karen Crawford take over the managerial duties for you on Sunday night?
yeah, she does all my bookwork and revenue and everything for me.
Other than Sundays, does Karen Crawford tend bar then?
Yes, she does.
So when she takes over the managerial duties on Sunday, does Stuart Tanner stand in for her at the bar?
Yes, he does. That's correct.
So he was tending bar on Sunday night of June the 12th, 1994?
Yes, he was.
Where was it that you last saw Ronald Goldman, sir?
I was speaking with him behind the bar that evening. That's the last time I spoke to him.
And after he spoke to you, did you observe him to speak with anyone else?
No, I did not.
For approximately how long after he clocked out on the time clock did he speak to you and other employees or stay in the restaurant?
I would say about 15 minutes.
So by your estimate, sir, you would say he left around 9:48, 9:50?
That's correct.
When he left, was he still wearing his uniform?
He did take his vest off and his tie.
But other than that, the shirt and the pants of the uniform he was still wearing when he left?
Yes, he was.
Did you ever see him again after that night?
No, I did not.
I have nothing further.
Mr. Shapiro.
Good afternoon, Mr. DeVella.
Yeah.
When you testified before the grand jury, do you recall being asked about the time periods involved as the prosecutor just asked you here today?
Yes, I did.
And do you recall what answers you gave them?
Similar answers that I did just a few minutes ago.
When you were asked approximately how long after Mr. Goldman clocked out did he remain, do you recall your answer was approximately 15 to 20 minutes?
It could have been, sir.
May I show you your testimony? Would that help refresh your memory?
Yes.
May I approach the witness,
Yes.
Your Honor? May I direct the court and the prosecutor to page 188 of the witness.
For the record, the court does not have that testimony.
Would you like to have that, Your Honor?
It's not necessary.
Thank you. Just take some time to refresh your memory. Have you had a chance to review your testimony before the grand jury?
Yes.
And do you recall what your testimony was regarding how long you stayed with Mr. Goldman after he had clocked out?
We talked for a few minutes.
And did you testify before the grand jury that he remained approximately 15 to 20 minutes after he clocked out?
Yes, I did.
What type of clock device do you have to record the times an employee clocks out?
It's an electric clock that was normal in most factories or restaurants, or you just put the time card in and it punches out the time, and that's it. It's very simple.
Do you know when the last time that time clock was checked for accuracy?
Well, I changed it when we changed the time when it was daylight savings time. So I pretty much have the clock within a minute or two, I would say, have accurate time.
Do you adjust the clock for time yourself?
I do, yes.
And what do you use to set the clock with?
There's a little lever that I press down.
What do you use to gauge what the time actually is?
My watch.
Did you see a pair of glasses that evening?
Yes, I did.
Where did you see them?
I saw Karen Crawford pick them up on the sidewalk outside the restaurant.
About what time did she pick them up?
I would say somewhere around 9:15 in that time frame.
Were you with her when she picked them up?
I was inside the restaurant and I saw her picking them up outside the restaurant.
Is there any reason that you watched her do this?
Well, I'm very observant in the restaurant. I have to watch my employees, I have to watch customers and make sure that they're comfortable and they don't need anything. So when I see my employee go outside, automatically my eyes turn to her, and I was just wondering what she was doing outside.
Where did you see her pick the glasses up from?
Right directly in front of the restaurant by the valet stand.
On the sidewalk?
It was on the sidewalk, yeah.
Could you tell what type of glasses they were?
They were wire-rimmed glasses, they looked like to me, from a distance.
Did they look to be clear glasses or sunglasses?
Clear.
Did you see what she did with the glasses?
She put them in an envelope.
Do you recall being asked those exact same questions before the grand jury last week?
No, I don't.
Let me ask you, the following questions were given to you on page 189 of the grand jury. Did you happen to see a pair of glasses that evening that was discussed? Answer, yes, I did. Question, and where did you see the glasses? Answer, I saw my bar manager picking them up off the sidewalk in front of the restaurant. Question, and who was the bar manager? Karen Crawford. Question, did you see what she did with the glasses after she picked them up? Answer, no, I didn't. Do you recall giving that testimony?
No, I don't.
Can I show it to you, please? Take as much time as you need to refresh your memory of what you just testified to last week.
Okay.
Was that your testimony as I read it, sir, before the grand jury?
Yes, it was.
Thank you. Nothing further.
Ms. Clark, do you have any further questions?
Yes, Your Honor, thank you. Mr. DeBello, when you just told counsel just now that you, I believe counsel asked you whether you knew what she did with the glasses?
At that time, I didn't know. It was told to me by Karen that she did put them in an envelope.
And when you were just asked by counsel if you knew what happened to the glasses, did you think he was talking about personally observing what happened to them after Karen Crawford picked them up?
Sustained.
Did you understand what counsel meant when he said, did you know what happened to the glasses?
I thought he was asking me basically what she did with them.
Did you think he was asking you whether you had actually personally seen what she had done with them?
No, I didn't.
But when you were asked before the grand jury, you were specifically asked in the following words, were you not, sir? Did you see what she did with the glasses after she picked them up? Do you recall that as just shown to you by counsel?
Right, I recall that.
And in response to that, you indicated?
I didn't see what she did with them.
Did you mean to indicate today to counsel that you did see what had happened?
As she was picking up the glasses, she brought them back in the restaurant. After that, I didn't see anything.
But what were you trying to indicate to counsel then when he asked you if you knew what happened to the glasses? Were you trying to indicate to him that you had seen what happened to the glasses?
Objection, leading and suggested motion to strike.
Overruled.
Yes, I was.
You were trying to tell him that you had seen what she did with the glasses after she found them?
Your Honor, asked and answered.
Overruled.
Yes, I was. I was trying to tell him that I'd seen her pick the glasses up and bring them back in the restaurant.
Okay. But were you also trying to tell him that you saw her put them in an envelope?
No, I wasn't.
Only you were trying to indicate what you knew after the fact.
That's right.
Thank you.
Mr. Shapiro, anything else?
Yes, just briefly. Mr. DeBello, you didn't see Mr. Goldman leave the restaurant, did you?
Not physically, no.
Thank you. Nothing further.
Ms. Clark, anything further?
I'm sorry. One more question. Was it about 15 to 20 minutes after he clocked out that you last saw him?
That's correct.
Thank you.
Do you have one more question, Mr. Shapiro?
I do not, Your Honor.
Sir, you may step down, and I just want to admonish you that until you have been officially excused from giving any further testimony in this matter, you are not to discuss your testimony with anyone except the lawyers in this case. Thank you very much.
Thank you, Judge.
All right, it is almost 4:30. We're not going to call another witness at this particular point in time. We are going to adjourn the proceedings for today until tomorrow morning at 9 o'clock. I would, however, like to see counsel in chambers with regard to some matters that we discussed earlier today for just a few moments with the reporter. Thank you. Good night.
Thank you.